All right, good morning, everyone. Welcome to the July 31st hearing board agenda. 2 items on the agenda today. We've got, just by way of introduction, members Bala Kapan, Verdugo Peralta, Dr. Abraham, myself. I'm the vice chair, but Mikhaili, the chair, is not here today, and attorney alternate is sitting in for him as a public member, Ms. Adrienne Conager-Macklin, and she must be sworn in because she was just reappointed as the attorney alternate. So can you do that now, Madam Clerk?
Sure. Morning. Okay. Raise your right hand, please, and repeat after me. I state your name.
I, Adrienne Conagar-Macklin,
During such times as I hold the above office,
during such time as I hold the above office,
do solemnly swear or affirm
do solemnly swear
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic.
against all enemies, foreign and domestic,
That I will bear truth, faith, and allegiance
that I will bear true faith and allegiance
to the Constitution of the United
to
States
the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California,
That I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion.
without any mental reservation or purpose of evasion,
And that I will well and faithfully discharge
and that I will well and faithfully discharge
the duties upon which I am about to enter.
the duties upon which I'm about to enter.
Thank you.
Thank you and welcome.
Thank you.
Formally,
Formally.
again. So those who might be looking in on Zoom and the webcast, obviously, since you're there, you know how to get into the video. Again, stay muted unless you have to speak when recognized. I think you press *6 to toggle the mute, unmute. And where there might be an opportunity for you to comment, *9 is how you would raise your hand. The items to be heard today are 2 cases. First is South Coast AQMD versus Los Angeles City Sanitation Bureau Hyperion Water Reclamation Plant, case number 1212-40, not 1212-39, a different case. And the second case will be the South Coast AQMD versus 3M Healthcare US OPCO LLC, case 6256-2. We will begin the proceedings with people who want to comment on matters not on the agenda. And so they could do that if they filled out a card in the back to comment on something not on the agenda within our jurisdiction. And after that, then we'll go directly to the first case, which will be the Hyperion case. So for those on the 3M Healthcare, it's kind of hard to predict when your case will come up, but we do have a lot of at least public commentators. So I'm sure the Hyperion case will probably be a couple hours minimum at least. So to begin, if someone wishes to comment on matters within your jurisdiction, not on the agenda, please raise your hand if you're in the audience and we can recognize you. Again, not on the agenda. Seeing none, Madam Clerk, is there anyone on the video that who suggests they want to speak on matters not on the agenda?
Well, there is someone online that has their hands raised. I don't know what topic they would like to discuss, so we'd have to ask.
Is there a way to
Day,
communicate?
Day? Okay.
Or chat with them?
Okay. E. Sassoon, are you there?
Yes, I am.
Okay. Could you let us know what, you have your hand raised. Could you let us know what item you would like to discuss or comment on?
Well, I just want to make sure that this was being recorded. I don't have any particular question at this time.
Yes, the proceedings are on are recorded and are on our webcast on the South Coast AQMD webpage.
Thank you.
You're welcome.
Thank you. All right, so we'll go to the first case. South Coast AQMD versus LA City Sanitation Bureau, number 1212-40. Ask the parties' representatives to come take the appropriate seats in front of us. All right, so the order of what we'll do is first we'll have the representatives identify themselves and spell their names. Secondly, we'll have a brief comment by Dr. Abraham and alternate member Conaga Macklin, just to verify that they've familiarized themselves with all the proceedings in this case, since they were not at some of the prior hearings, to see if the parties accept their appearance on the panel today. Third, we'll label the exhibits that have been provided. And fourth, we'll swear in all the witnesses that you propose that are here. That would also include any public members who wish to testify as opposed to just provide commentary. And again, to state to the public as set forth in the agenda, if you simply comment, then that's something that we can take into account in our deliberations. If you want to have more of a factual basis for your testimony to be evidence that we can consider, you would have to be sworn in, and then your testimony will be subject to cross-examination. If you're just a public member who wants to comment, again, no need to be sworn in, no need to be subject to cross-examination. So that's kind of the order of what we'll get to before we actually have the meats of the discussion. So first, can we identify who we have here for the district?
Hi, good morning. Erica Chavez on behalf of the executive officer.
Spell your name for the record, please.
ErikaChavez.
Thank you.
Oh, this will be my witness coming up.
Oh, okay, okay. Hyperion, please.
Hello, Adina Hopenstand, Deputy City Attorney on behalf of the respondent, City of Los Angeles, including its Hyperion Water Reclamation Plan.
And that's Hopenstand.
Yes.
And who's with you?
Good morning, Virginia Choi, Deputy City Attorney on behalf of the respondent, CHOI.
Thank you, thank you. All right. I'll go with Dr. Abraham first, again, since you went to all the hearings, just to make sure that you can state whether you feel capable in handling this hearing today and have reviewed materials in the past, et cetera, et cetera.
Okay, thank you so much. I have reviewed the materials from the previous hearings, including what has been provided before us today, and so I feel comfortable being a part of this hearing if there are no objections from either party. There's no objection.
Ms. Chavez, any objection to either member?
No objection.
Ms. Hopenstand?
No objection.
Thank you very much. Okay. Let's get the exhibits in, because some of the exhibits also reflect comments and that might perhaps shorten public comment, or at least make sure that they know their voice has been heard. So, Madam Clerk, can you help me with the numbering of the exhibits that we've been handed today? We have a status report from Hyperion. We have a proposed final decision from AQMD, and then we have a number of emails that were provided from the public, it appears.
So for the petitioner, we'll start with X, Exhibit X.
All right, so that's the proposed findings and decision.
Yes.
Okay. I believe that's the only one additional from the petition that I can recall, correct?
Correct.
Thank you. And for the respondent, the status report?
That would
term it,
We would start with number 9.
number 9. Okay. And then do we call these public comments hearing board exhibits? Is that what we normally do, how we label them? Okay. I'll go with whatever order that you have, Madam Clerk.
Okay. And we'll start with 20. So we have the comment from Aaron Falati, number 20,
Hearing board 20, all right.
or Publix Exhibit 20. Nancy Johns, 21.
Hold on, 21. All right,
Then Holly Shelton, 22.
okay.
And then we have 2 from Tamara, and I'm sorry, I can't pronounce the last name, Kuchowski.
Mhm.
So we'll, number, let's see, 23 will be the email dated July 29.
23. Okay.
24 will be her email dated July 30th.
Okay.
And then, let's see. For number 25 is a letter from Katina Wong.
All right, 25, Trina Wong.
And then we have an email from Lucia Burnham, would be number 26.
26, Ms. Burnham.
And then 27 from Chuck Espinosa, an email.
27.
And I believe those are all the public comment letters.
That's all that I have too.
Mhm.
All right. Thank you, thank you. Just a second here. All right, so those who will testify, who are witnesses for the parties, as well, again, as a member of the public who wishes to testify and therefore be subject to cross-examination, we'd like you to stand and raise your right hand if you could. And just repeat, do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth? Please verbalize it. Thank you, thank you. All right, so again, the first case we're hearing is Hyperion Water Reclamation Plant. So you'll have 3 minutes in terms of either comments or testimony to present. We have some cards already filled out. One from Mr. Boyles, which is public comment.
Chair, I'd like to change that to testimony, please, if possible.
Did you take the oath, sir?
Yes.
Okay, we'll put down public comment. We have Katrina Wong, public comment, and Ms. Kikowski, who is both public comment and public witness. So we'll presume that's public witness unless you change your mind. So, Mr. Boyles, you're first, and then it'll be Ms. Wong and Ms. Kikowski. And again, the video person will put on a 3-minute clock, and please try and honor it because we do have a number of speakers and a lot to go through today.
There we go. Thank you, Chair and the board, for the opportunity. Thank you, Inspector Haynes and your team. Where are you at there? He's there somewhere. Thank you for everything you've done for the city of El Segundo. Thank you to Tamara and Katina and all the El Segundo residents that have put in countless hours along with the inspectors in this matter. I've been the mayor of El Segundo since 2018. I've been on city council since 2016. I've lived in El Segundo since the mid-90s. I provide this background to give you a little context. I'm not new to the city, and I'm certainly not new to Hyperion. In July of 2021, while I was mayor, I got a call from Supervisor Janice Hahn. Drew, I think we have a problem, literally is how the phone call went. One of my supervisors informed me we have a major spill from Hyperion that has affected all the nearby beaches. That is the catalyst for this spill. That communication, inadequate communication, unfortunately remains to be the protocol with which we received by the city of LA. We've tried so much, yet it remains the most frustrating and maddening issue that affects the health, welfare, and the quality of our constituents. As an elected official, we feel helpless on so many occasions. We sent a letter to Mayor Bass calling for a leadership change. We brought together Congressman Ted Lieu and many other elected officials to exert pressure on the city of LA. We hired an expert, Dr. Wayne Stenstrom. We created a subcommittee within our council to continue to push this issue. We authorized litigation, and until this point, we've avoided doing so as a city. Ultimately, you all have the authority to improve our health and quality in a lasting and meaningful way, and that's what we're looking for. By the way, the clock's not on the 3-minute clock, sir. Oh, it's right there? Okay, thank you. Here are the facts. Before the nearly catastrophic spill at Hyperion in July of 2021, AQMD had issued Hyperion 7 notices of violation since 1985. That's over 36 years. Since that July spill, roughly 3 years ago, there have been 93 notices of violations. Most of these were issued in 2021 and 22 and 2023. We thought things were actually improving since we only had 3 NOVs. Then in January of 2024, the plant started to decline again. 16 NOVs have been issued so far this year, and we're only halfway through the year. If history is any indication, this uptick in NOVs is a signal that more failures and potential disasters are likely in our future. So here's what we implore you to do. We request AQMD to have Hyperion significantly raise the level of attention with respect to the following: air monitoring, better oversight of the vendor who manages the installed air monitoring system. The goal here to have the system register accurate H2S concentration readings and minimize the number of breakdowns, which have been fairly rampant recently. By the way, we had to lobby Assembly Member Marisucci. I personally made that request to get that fence line monitoring in place. Equipment failures, improved and more timely communication with the city. February, we had a flooding at Hyperion, and we learned about the flooding at a regularly scheduled sanitation meeting, not through Hyperion. April, we had a digester leak, and we learned about that through AQMD, not Hyperion. We want better planned maintenance. I'm sorry if I'm running over our time. If you could just give me a few. Thank you. We want better breakdown and spill reports, and we need AQMD to consider Hyperion a priority. We know you have a large range of authority. We implore you to get better results out of the largest wastewater treatment plant west of the Mississippi. Thank you very much for your time.
Since you're a witness, if either party wants to examine you, they can. So remain at the podium. Ms. Chavez?
Thank you for your comments. No questions at this time.
Ms. Hoppenstein?
No questions at this time. Thank you.
Thank you, Mayor Boyles. Faye, is it true that the clock doesn't show here just on the screen for the quick? Okay, okay. All right, Katrina Wong, public witness, somebody public comment, Katrina Wong. And if anybody on the video is going to be a comment or witness, keep your hand raised and we'll get to you after the ones in the audience have spoken.
Good morning. Thank you for the opportunity. I'm Katrina Wong. I actually live on the south side of the Hyperion. I've been there since 1970. The last 4 nights, the Hyperion Southern H2S monitors have read over two PBBs. And every night results in headaches, earaches, breathing difficulties, coughing, nausea, body temperature fluctuations. My head feels like it's floating, and difficult being able to concentrate, even spell words or sentences. The citizens of El Segundo know that the Hyperion is emitting more than the monitored H2S. And the symptoms we experience on a daily basis is proof of the suffering that's being caused. The board has the power to protect the community and the future generations that reside in it. And I encourage you not to remove the current Hyperion abatement, that it may be the only thing currently protecting this community from the audicities of the Hyperion. And you have a letter from me that has more information, and thank you.
Thank you. That was just public comment. So next, we have Tamara Kichowski. Forgive me if I mispronounced the name, for public witness. If that's what you choose, you check both boxes. Good morning. You did stand and take the oath earlier?
I did.
All right. Public witness it is.
Okay.
The floor is yours.
Thank you. Good morning, esteemed board members, and thank you for the opportunity to speak here before you today and your willingness to hear our pleas. I'm respectfully asking you not to lift the orders of abatement against Hyperion. They are not abiding by the orders that you imposed. I have laid out my reasons for you in written comments and with attachments too vast to cover here in this limited amount of time. Those of us who have sent in written comments or are participating online are not zealots as we've been described as. We are simply the last residents left standing and haven't given up the fight as many of our neighbors already have. I'm asking you not to be part of the machine that I refer to as the GPGP, Government Protecting Government Program. We've all witnessed how industry has hurt our air, water, land, and therefore our health. The difference lies in how private industry is treated versus government owned and operated. Look no further than those private businesses along the Dominguez Channel in Carson, and you'll find a swift cleanup and hefty penalties in the millions. Why should Hyperion and LA Sand be treated any different? For over 3 long years, we've been subjected to their abuse by not playing by the rules. They claim everything is back to normal. That's a complete fallacy. evidenced by the event of June 27th of Hyperion exceeding their 30 parts per billion permit to 31 parts per billion. We were driven from our homes without notice, without the opportunity to file a complaint from our homes, as we are required by your verification process. In order to avoid vomiting, headaches, and much more, we had to flee the area immediately and forego meeting with an inspector. To add insult to injury, the very next day, Tanya Sheldon from LA Sand sent out an email to the residents claiming that the very exceedance was an error and adjusted the H2S readings to just 27 parts per billion. I believe in order to avoid an automatic notice of violation. If that isn't bad enough, now they've gone back and quietly adjusted the monitoring graph to show the levels of H2S at a mere 1.4. So not only is that a slap in the face, but it's beyond egregious. And I believe it was done intentionally to mess with the historical data. We know it, and now so do you. The images of those are also in my comments, my written comments. I don't envy Hyperion's legal, I don't. After all, she's just doing her job. But I can't fathom how she and the representatives from Hyperion here today go home and sleep soundly at night and continue to spew toxins and odors, vile odors that continue to sicken the community. On the other hand, this hearing board has not only the opportunity to right this ship and hold them accountable by not lifting the abatement orders, but you also have the power to do just that. I will not go quietly because we wake up to odors and we go to sleep with them. Enough is enough. Thank you for your time.
Thank you. Since you're a witness, remain there in case anyone has questions. Ms. Chavez?
Yes, a few questions. Thank you for your comment. I believe you sent in a letter. Is that correct?
Yes.
Okay. And did you reference making complaints to the Hyperion's 24-hour hotline?
Yes.
Okay. And have you ever been contacted by Hyperion after you make those complaints?
Never.
Okay. It's a no call?
No phone call, and I request them each and every time. I request that in the written report of findings.
Okay. And no email?
No emails from them from LA San either. I just get the written reports of findings, but I don't get them 100%, which they're required to do.
How often would you say you receive written reports after a findings?
There are dates in my letter, my written letter, and it has the exact dates that I did not receive those findings, and that amounts to 34% of the time. And it's also should be noted that since January, I have filed over 110 phone calls and complaints to AQMD, and approximately, I want to say 47 to Hyperion.
Okay, and you said 34% of the time you receive a written report.
Don't receive
You don't
written
receive.
report.
Okay. Okay. Thank you for your time.
Ms. Hoppenstein?
No questions.
Any board members have any questions? All right, thank you very much for your testimony. Anybody on the Zoom call, Madam Clerk, that might appear to want to give public comment or public testimony on this matter?
No raised hands.
All right, then we'll assume there's none. So this is a status report, so I guess, Ms. Chavez, you'll go first. The opening statement.
Sure. Good morning, members of the board. We are here for a status and modification hearing on the nuisance order for abatement issued against LA Sanitation Hyperion Treatment Plant. The order for abatement currently expires August 30th, and today the district is seeking an extension of the order through the end of the year. This is a stipulated proposed modification. The district is not proposing any additional conditions at this time. This extension is necessary because Hyperion continues to fail to adhere to certain conditions ordered by this board. Additionally, there have been recent nuisance NOVs issued in July to Hyperion. District Inspector Farrar Lay will first provide an overview of odor complaints and nuisance NOVs issued since the last date of hearing in January. Next, Inspector Haynes will address Hyperion's compliance with the order for abatement conditions. You have seen letters from El Segundo residents and have heard more today that it is critical for the order to be maintained, to continue to closely monitor odors, and to require compliance with all this board's ordered conditions that have helped improve operations at Hyperion. Thank you.
Before you start, Ms. Hoppenstadt, I, for one, would have liked to have seen the NOVs in our package. Is it possible that while we have the deliberations, someone could make copies for us? The ones that happened in July, for example, you mentioned?
Yes, I can do that.
I appreciate that. Ms. Hoppenstadt?
Thank you. At all times during the pendency of this matter, respondent City of Los Angeles, including its Hyperion facility, has heard from this board, from South Coast Air Quality Management District staff, and the members of the community regarding their concerns with the Hyperion facility. Respondent takes all these comments seriously and with the urgency that this board, South Coast staff, and the public expect, and has always prioritized addressing such concerns swiftly and incorporating constructive input where possible. Today, you will hear about Hyperion's timely completion of all the capital projects required under the abatement order, with the completion of the primary tank D cover replacement. While the timeline provided under the abatement order was challenging, Hyperion ensured that the projects under the order remained its top priority, and it is proud to have completed the project by the June deadline, as shared in respondent's July 25 status report. We understand that nonetheless, the district would like to extend the abatement order, which respondent does not oppose.
Thank you. All right. So, Ms. Chavez, sometimes we have questions as the board for a witness, and then it turns out there's another person who's better responded. So before you start, just lay out who you have available or who you might participate in what order and what their jurisdiction is, so kind of we'll have a head's eye view of what's going on.
Yes, first I have Inspector Vander Ferley. He will discuss complaint counts and NOV counts over the last several months, as he has responded more to the complaints over the last 6 months or so. And then I will have Inspector Haynes, who can discuss the compliance with the OA conditions and certain investigations. I think February spill was mentioned. Inspector Haynes will discuss that as well.
Very good. All right, your first witness, and please spell your name and identify your title on the record, please, sir.
My name is Vander Ferrerle. I'm an Air Quality Inspector 2 with South Coast AQMD. My name is spelled Vander, first name. Last name is Ferrer-Le.
Sir.
And how long have you been in your current position?
I've been an Inspector 2 since February of 2024.
Okay, and are you familiar with Hyperion?
Yes,
Okay, and can you describe your familiarity?
I was the backup inspector for the Title V inspection of the previous cycle, and I was the lead inspector for the Title V inspection for this cycle.
Okay, and have you been responding to complaints about Hyperion?
Yes,
Okay, and how long have you done that for?
since December of 2023.
Okay. And does anybody else from the district respond to complaints?
Yes, I have a backup inspector,
Okay, and who's that?
Inspector Justin Buncab.
Okay. And did you review anything to prepare for your testimony today?
Yes, I reviewed NOVs, NOV reports, and complaint counts.
Okay. All right. So first talking about the odor complaint count, does the district continue to receive odor complaints about Hyperion?
Yes.
Okay. And so can you tell us the odor complaint counts for the last 6 months, starting in January 2024?
In January of 2024, we received 106 complaints. February, we received 401 complaints. March, we received 135 complaints. April, we received 128 complaints. May, we received 131 complaints. June, we received 125 complaints. And in July through July 29th, we received 116 complaints.
Okay. And so you mentioned February had a significant amount of complaints. It was like 401, you said. Do you know what happened in February to cause the large amount of odor complaints?
Yes, there was a large storm event that forced the facility to route the flow to Battery D. And I understand that Hyperion has an ex-party variance that allowed them to route that flow into Battery D.
Okay, thank you. And aside from that February event, does it appear that the complaint counts have remained steady?
Yes,
Okay. Now turning to the NOVs, were you able to review the notices of violation for nuisance that have been issued since the last data hearing in January?
yes,
Okay, and has the district issued any NOVs since January?
yes, 17,
17, okay, since the last date of hearing, January 24th, correct?
correct.
Okay. Can you give us a breakdown by month of how many NOVs were issued?
Yes, so since January of 2024, after the hearing, in January, there was 2 NOVs. In February, there were 9 NOVs. In March, there was 1 NOV. In April, there was 3 NOVs. In May, there was 0. In June, there was 0. And in July, there was 2.
Thank you. Okay, so we have a large amount of NOVs in February again, and was that likely to be caused by the storm and Hyperion's use of tank D, like you stated?
Yes,
Okay. And after February, the NOVs appear to drop again, correct?
yes,
Okay, and you said for May and June, there were no NOVs issued?
correct.
Okay. All right. And if you are aware, was this around the time that Hyperion completed their installation of the tank covers and seal replacement on the remaining battery tank?
Correct.
Okay. All right. So in July, you said that there have 2 NOVs been issued. Can you tell us when those were issued?
Yes, they were issued on July 9th and July 12th.
Okay. And did you issue the NOVs?
I issued on July 9th.
Okay. So can you tell us briefly about your investigation?
Yes, in the morning of July 9th, I received numerous complaints dispatched to me via email from my supervisor. We do conduct our regular surveillance of Hyperion on Tuesdays. And so I met with the complainants, verified the odors that they were detecting, mostly sewage and rotten egg odors. And once a certain number of violations, once a certain amount of odors were verified with complainants, I did my upwind and downwind surveillance to verify those odors were coming from the facility. And once I arrived at the facility, I issued the NOV to the facility, to the shift supervisor.
Okay. And how many complaints were verified that day?
I believe 9.
Okay. And what did you smell when you were out there?
I detected sewage and rotten egg odors.
Okay. And is there an intensity scale that you would say?
Yes, we rate the scale from 1 to 5.
And what would you have rated it at?
About a 4.
About a 4. Okay. And did you visit the facility afterwards? You issued their NOV?
Correct. I visited the facility and I requested documentation.
Okay. And what kind of documentation?
I requested the shift supervisor logs, which state the operations ongoing at the facility.
Okay. And let's see. Do those records include odor complaints or corrective actions taken, investigations, or can you tell us a little bit what it includes?
Yes, so shift supervisor logs have a number of the operations ongoing on the plant, whether it's breakdowns or if there's maintenance, corrective actions as well. And I also requested odor complaint logs from the shift supervisor.
Okay. And so in your investigation and your review of records, did anything indicate any possible cause of the increased odors that day?
Yes, there was a primary tank cleaning on that day.
Okay. And was that cleaning was the district given notice of that cleaning ahead of that day?
No,
No, okay. All right. Are you aware of the circumstances that caused the NOV to be issued on July 12th?
yes,
Okay, you did not issue that one, correct?
correct.
Okay. How are you aware of the circumstances that caused it to be issued?
I was provided the shift supervisor or the shift supervisor records that was requested by the inspector that issued the NOV.
Okay, and can you tell us what the records from that day, if they indicate any cause of odors?
Yes, the records indicated digester 1D1 cleaning.
Okay, and was the district notified of any cleaning for that day?
I'm unaware if they were.
Okay. Okay, do you happen to know how many complaints were verified that day?
I'm unaware exactly.
All right. I don't have any other questions at this time.
Just a few questions. Do you recall speaking about the February storm event in your testimony a few minutes ago?
Correct.
And are you aware that that storm event was declared as a California state of emergency?
Correct.
And did you hear the public testimony provided by Tamara with the last name beginning with a K?
Correct.
And in that public testimony today, as well as in a written submission, she referred to June 27 readings. Do you recall that testimony or that public comment?
Correct, I do.
And did you do an investigation to confirm that the readings above 30 parts per billion on June 27 was an invalid reading?
I did conduct an investigation.
And were you satisfied with the results of that investigation?
Currently, at this time, we've received a letter from Montrose that indicated that the data from that day should be invalidated.
And Montrose is the operator of that fence line system, is that right?
Correct.
It's not run by Hyperion, correct?
Correct.
And does the district also receive 5-minute data readings for each of the Teledyne units?
I'm unaware.
All right, thank you very much.
No, thank you.
Yes, I have a question in reference to, sir, when you went out to Hyperion on July 9th, did you have an opportunity, and maybe you don't, when you go out to these inspections, do you have any opportunity to speak to any members of the public when you go out?
Yes, when we receive complaints to the district, they're submitted by members of the public.
And
So,
on this date, did you speak to members of the public?
yes, I did.
And what were their comments?
They reported the same consistent odors that I detected.
Okay, and how many members of the public did you speak to?
I spoke with 9.
9, okay, thank you. Were you involved with Hyperion in February?
Yes, I was.
Okay, and as we're being told now, that was a time when the storms were being, I guess you could say, grouped into a category having to do with the state's emergency response and emergency situation. But prior to that, or immediately prior to that, were there notices of violation, or were there times that you needed to go out there based on the complaints that you were receiving?
Yes.
Okay. Approximately how close to that occurrence of that storm? Just about ballpark is good enough.
I'm unaware of exactly when the storm occurred, but we do have a number of NOVs issued throughout February.
I see that. I see that. My concern is that I don't want all of the notices of violation to be dismissed, if you will, because there was a governor's emergency status going on, because I still think, and I've been listening to all of these complaints from the members of the public for several years now. And whether it was under an emergency status or not, there has been continued notices of violation prior to and post period of time. So that concerns me greatly. And the fact that the members of the public are still complaining after all these years. And I don't, as many times as we've had them here, I don't see that there's enough of an improvement for there not to be notices of violation. And why we would not continue jurisdiction over Hyperion, I don't think I could ever agree upon that, but I absolutely appreciate your going out there and taking down all of the data so that we are able to better make a decision on this.
Thank you.
Thank you.
Dr. Abraham?
No, I have no questions. Thank you.
Mohan?
Good morning, Inspector Farrell. The February complaint was a rain event you mentioned, right? The 411 complaints.
Correct.
And you said it was routed to battery D. Is that correct?
Correct. Primary battery D.
Was that the one that was under repair or?
Correct. At the time, their replacement covers were not completed.
Why do you know why they routed to a battery that was under repair and needs to be covered properly?
They were over capacity. And so if they didn't route the flow into the primary battery, it could have caused some damage to other parts of the facility.
So, so they did route it to all the ABC and then, but still over capacity because of the rain, and they had to go to D, and then that caused, because it was not adequately covered there, all the complaints.
Correct.
Okay. Now, have you talked to them about it? And when the future rain events are going to occur, such as this, it appears, what seems to be the problem? Can they not handle it at the upfront during the initial stage at the of the plant versus routing it?
I'm unaware of their current plans for any future storm events. I'm not sure if they have any plans for any future storms.
Let me go back to the notice of violation you issued on July 9th, and you smelled the odor and the odors. You experienced it. Now, and you got the reports. Were they specific to what was occurring that caused the accidents or the odors?
The documentation reported that there was cleaning of the primary tanks. That's typically, or when I did my surveillance of the facility, I detected the similar odors that I detected in the neighborhood.
Did you observe was the cleaning going on at that time?
Correct. I observed the cleaning.
You observed the cleaning, and were there any controls in place during the cleaning to vent the tank?
They do use odor fans, but I'm unaware of any other.
When you say odor fans, you mean what exactly is that?
They're fans that they use to attempt to mitigate the odors around the
blow it from
blowers.
there.
Correct.
And that which direction does it go to?
I'm unaware of the direction.
Okay. And you heard testimony earlier from Ms. Tamara about the July 27 reading. I think she said that they sent us running from our homes. So there's clearly an event occurring, and then you got Montrose saying there was a wrong reading. How I'm difficulty computing that. If the witness said they had to flee because of the high odor threshold, high odors. And so did you question why Montrose said that was a wrong reading, and what led to the wrong reading?
Yeah, so the investigation is still ongoing at this time. So there's no definitive answer yet, but I'm just relaying what I received from Montrose.
But they've revised it to a 1.4 now.
I believe so.
Okay, and that's still been investigated?
Correct. The investigation is still ongoing.
Now, you also mentioned on the July 12 NOV, there was another tank cleaning. Which one? You said D1 or
Digester 1D1.
Digester 1, D1?
Correct.
So again, you didn't observe that because it was another inspector who gave the NOV.
Correct.
But did you review his report to indicate that showed what was going on? Or?
The report is still in progress, but I did review the shift supervisor logs that they had acquired.
And again, did they log show what kind of, if they had put in any control or any form of, besides the fan?
I'm unaware of any controls that were in place during
and I know you've joined the district recently, but do you have any thoughts on what kind of controls they could do to mitigate during cleaning operation?
I'm unaware of any specific controls that they can implement.
So
at this
can
time.
you describe a little bit the tank? It's an open tank?
So the primary tanks?
Yeah, that they were cleaning that caused the problem.
Yeah, so the primary tanks is where the wastewater initially flows into for processing. They are typically covered with the replacement covers, but if they are opened, it's typically for cleaning or maintenance.
And to your knowledge, they have not put any kind of temporary control, odor control at all while they're cleaning?
I'm unaware of any further controls that I've observed.
All right. Okay, thank you. I have no further question.
I do have a question.
First?
All right. In December of 2022, December 20th of 2022, there was a odor model analysis report prepared. Do you have any information on whether or not there was any follow-up on that report? And if any measures have been taken to abate the odors that are there based upon that report?
I'm unaware of any follow-up to that report. That was before my involvement with Hyperion.
And has a plan been presented at all concerning the abatement of the odors? No, please go on.
I'm unaware of any plan at this time in regards to the abatement.
All right, thank you.
Thank you. Do you know whether Montrose is a third-party contractor to Hyperion?
Yes, Montrose is a third-party contractor.
And therefore, who pays Montrose?
I'm unaware of who funds Montrose.
Okay, thank you.
Anything else, board members?
Just as one quick follow-up. I thought I heard Ms. Chavez say the order is to extend it to the end of the year, but I see in the finding a decision January 3rd, 2025. Is that correct?
Yes, that's what we're seeking today.
January 3rd, and then with a status hearing on November 20th.
Correct.
All right, thank you.
All right, thank you, sir. Appreciate your testimony. Next witness, please.
Yes, Inspector Michael Haynes.
Thank you, thank you. Good morning, board.
Good morning. Please
How you doing?
state your name and spell your name and state your title as well, sir.
First name is Michael, spelled M-I-C-H-A-L. Last name is Haynes, H-A-Y-N-E-S. I'm an Air Quality Inspector 3.
And I saw you take the oath, so please continue, Ms. Chavez.
Thank you. Okay, let's see. Did you review anything to prepare for your testimony today?
Yes, I did.
And what was that?
Notice violation reports, Hyperion treatment plant reports, especially complaint logs, some of their shift records, and also some of the district inspector logs.
Okay. And in the past, you've testified on the odor complaints and nuisance violations, but has your capacity as the inspector for Hyperion changed somewhat?
I guess it does.
Okay, and in what way?
I'm a backup to the backup to the backup at this point in time. However, I've been assigned to investigate and inspect all order of abatement related issues at Hyperion Treatment Plant. Therefore, for the last 3 months, I've inspected Hyperion Treatment Plant every Saturday between the hours of 8 and 3 p.m. for order of abatement related issues.
Okay, thank you. So no, not really responding to complaints as much, but mainly following the order of abatement conditions.
That's good.
Okay. Okay, and let's see. So let's talk about the tank covers first. When we were last here in January, there was an outstanding project for Hyperion to complete. Is that correct?
Yes, it is.
And what was that?
That was to finish completing the tank covers, especially on primary battery number D.
Okay. And since the last hearing, has that been completed? And when was that?
It was in June, I want to say the 6th. My date may be incorrect, but I know it was in June. I'm almost sure it was June 2024.
Okay. And remaining battery D was supposed to remain offline until the covers were completed in June. Was that correct?
Yes.
Okay. And then there was an incident in February where battery D was used, correct?
That is correct.
So can you tell us what happened exactly as far as the incident and battery D being used?
Yeah, my agency received complaints as well as breakdowns on February the 4th as well as February the 5th. I believe on the 5th, we actually received 2 breakdowns. On the 4th, however, I had an opportunity to be on site. I showed up, standard introductions through the guard system, arrived at the control room, I don't know, somewhere, maybe about 15 minutes upon arrival. Something was strange because when I walked into the control room, instead of just seeing shift suits and operators, I saw some of the higher ranking personnel of the Los Angeles Sanitation Department standing around looking at screens and looking at documents. I inquired with the shift supervisor, was there a problem? Was there a breakdown? Was there an incident? He informed me roughly at around 10 a.m. that day, the headworks suffered a major leak or spill, and the debris came out of the headworks building, and subsequent the flow was so high, they had to redirect the flow into multiple primaries, including primary battery D, and he did indicate to me that it was an emergency.
Okay. And are you aware that if Hyperion obtained a variance from the OA condition to not use that battery D?
Well, the order of abatement would not allow them to use battery D, and then ultimately they did get an ex parte variance to utilize battery D for storage of that material. So,
Okay. And how long, or do you know how long that event lasted and how long they needed to use battery D?
from my understanding, they utilize battery D. They still utilize battery D. From my understanding, they're actually cleaning some of that waste out that had to be stored in some of these primaries. So it's still there from what shift suits have informed me. I was recently out there this past Saturday and confirmed that they had been doing some cleaning of the primaries. I looked on the shift logs as well as the Hyperion Treatment Plant complaint logs. Oh, by the way, these are logs in which complainants, residents in the city of El Segundo, phone in Hyperion Treatment Plant. They do their own independent investigation. I review these records. Anyway, on these records, it did show that they had problems with odors on that day. I want to say it was July the 26th, and it was associated with them cleaning battery B, not prep battery D. I inquired with the shift suit, why are you cleaning battery B? And he said to me that they were cleaning the residue from the spill that occurred in February, which was a little shocking to me, but you know, Hyperion, it's been shocking all along. But subsequently, that's what he informed me. I inquired with him what was the current flow. This is the flow that's coming into the plant. They average normally in the morning, it's high, and midday it flows a little bit. Anyway, the flows were like 150, 170. And I said, well, what was it during the February incident? And it got up to 700 million gallons. So that was the reason. I think you heard the previous inspector indicate that they had to reshuffle and redirect the flow. 700 million gallons is unheard of for a Hyperion treatment plant to handle. So I do agree with them, it was an emergency, but that's a lot of waste. And so they had to redirect it someplace. And pretty much that's what happened in February. One of the incidents that what they did.
Okay, thank you. Do you happen to know their capacity, Hyperion's capacity?
Well, it varies from hour to hour, but it averages somewhere between 250 and maybe 350 million gallons a day.
Okay. Okay, and so you said that they continued to use battery D from that February spill and it was never really cleaned out, or to your knowledge?
To my knowledge.
Okay. Okay. Are there any other problems remaining from the February incident?
That I'm aware of. I mean, there's been some incidents talking with other inspectors associated with the fence line. Of course, you know, the standard public nuisance violations have been issued associated with odors. There's been issues of when I've reviewed their logs about truck loading facility doors being open, kept open even during loading. Remember, when they're loading materials, the truck loading doors, headwork doors, grid barn doors, all these doors, ladies and gentlemen, must be closed when they're loading this odorous material, sewage filter tape. However, on these particular days, their records showed differently. Their records showed that these doors were open, according to their own operator who generated these records. And again, some of the records do show that they were loading filter tape during this time, which is a violation of the order, certain violations of their Title V.
Okay. All right, 1 second. Let's take, you mentioned earlier that every Saturday for the last 6 months or so, is that correct? That you were at Hyperion for a few hours to follow up on order for abatement conditions, correct?
Correct, and sometimes it varies from Saturdays to Mondays, but between Saturdays and Mondays, I'm out there.
Okay, and so what are you doing during that time?
Upon arrival, once I get permission to inspect and review records from their shift suit, I then review their shift suit logs, normally from the previous week. So theoretically, I would normally review anywhere between 7 to 10 shift logs, and each log is approximately 3 pages, maybe 4 pages, maybe about 100 entries in it. I also look at their fence line numbers, meaning their monitoring station, which normally averages somewhere between 2.5 and maybe 6 to 7 parts per billion. And then also I review their Hyperion treatment plant complaint logs. And again, as I stated earlier, these are logs that show who phoned in Hyperion to Hyperion treatment plant regarding odors. It lists the time, it lists the date, it lists the complainant's name, their phone number, it lists the operator, Hyperion treatment plant's operator that inspects and verifies where these odors may have originated from the plant. So those are the majority of the records that I normally look at. I also look at their headworks facility logs. I also look at any maintenance logs that they show me upon arrival. And then I do a precursor, either drive around or walk around the facility to see if the barn doors are open and things of that sort. So yes, it's a standard day. Excuse me. And prior to that, I normally do surveillance in the community before I contact Hyperion Treatment Plant. So I go into El Segundo, east of the facility, and I'm in the, I would say the neighborhood for maybe about a half an hour, 45 minutes before surveillance stops, 3 downwind, 1 upwind. Once I complete that, if there are no odors that I detect, or if they're faint, that wind speed, wind direction, temperature, things of that sort. I call my agency to see if there's any open complaints. Sometimes I'm able to reach the standby supervisor, sometimes I'm not. From there, I drive to normally Imperial, and this is there, I would say right there on the corner of Hyperion, and I do an upwind air samples surveillance at that point. Then I go into the plant. I get through the guard, notify the guard that I'm on site. The reason why, they normally notify the control room that I'm on site. So at that point in time, Hyperion Treatment Plant is aware that a governmental agency is on site. And on my way to the control room, I do surveillance of their grid barn. I do surveillance of their primary batteries. I do surveillance of their digester solids facility building. And then I arrive at the control room, meet and discuss elements with their shift supervisor. I'm not really talking to their operators, but I do interface with the control room operators and identify have they received any complaints that day. I also inquire with the operator who is monitoring flow, and I always get the current flow, which changes daily, hourly, to be truthful. And subsequently, once I review all that, I discuss any findings with their shift supervisor, and then I normally depart. So I'm actually in the plant maybe about 3 hours, and I'm in that area maybe a total of about 5 hours, give or take. Some days it's maybe 4 hours, but most of the time I'm out there about 5 hours.
Thank you. Okay, so you discussed in there that you're seeing some problems with the truck loading and unloading facilities, the doors not being closed. Can you just, well, first off, what condition is this referring to in the order for abatement?
That would be 1E, ladies and gentlemen. So we do have the order of abatement.
I think the truck loading facilities, would that be condition 41?
That would be condition 41. Oh. So it would be condition 41 in the order of abatement, ladies and gentlemen.
Okay, and so can you tell us what it is that, let me see here. How do you become aware that Hyperion is violating this condition?
From their logs, and then also observations.
Okay, and when you say logs, are you talking about complaint logs?
I'm talking about the Hyperion Treatment Plant complaint log that shuttles any complaints that come into their plant. They document it as Hyperion Treatment Plant record of outside contact. I treat it as a complaint log, but the actual wording on it is record of outside contact.
Okay, and as far as you're aware, that's when a public member calls into Hyperion and Hyperion does their internal investigation into the complaint, correct?
That is correct.
Okay, and so these complaint logs will show what corrective actions have been taken. Is that correct?
That is correct.
Okay, so so you're seeing this condition is being violated in this complaint log. Can you give us an example, if you have one?
Yes, I have an example. July the 26th. I will not introduce the name of the complainant. We're trying to keep that confidential. But on this log, it indicates the APC operator. That is the operator, Hyperion Treatment Plant operator, that actually conducted this complaint investigation regarding odors. It also indicates wind speed, humidity, wind direction. It also indicates the operator that's actually at the buildings. It also indicates the phone number of the complainant. It also has categories that says call back requested and time called back. Normally in these particular statements, I'm looking for a time to show that when the complainant was actually contacted by HTP. Board, you got to remember, when we go out there, we have to contact the complainants so that we understand when they smelled the odors, what direction the odors were coming from, and the potential level of the odors, such as, was it real bad? Was it not bad? Was it faint? On the logs are what we indicated in the order of abatement, they have to do it by numbers, a number scale, 1, 2, 3, 4, 5, etc. Also, it does not show when they contacted the complainant. So let me make it real clear. How do you do an odor investigation and you don't contact the people that phoned in the complaint? It's unheard of. We couldn't do that. These 402s we've issued, we will never be able to verify that if we don't contact the complainant. So how do you investigate an odor complaint without contacting the complainant? There's no evidence of this. And when talking to the complainants, they tell Hyperion to call them back and nothing is done. So when I'm looking at these reports, it has a process area, it has DSF doors open. We have headworks doors open. We have truck loading facility doors open. Now, of course, the doors have to be closed during any type of truck load per the order of abatement. According to this, they were loading trucks and the doors were open. That's against the law. You can't do that. It's a violation of the order of abatement. That's in violation of the Title V. You have to control the odors from the truck loading building. So if you're not controlling the odors and you're not contacting complainants, then what sort of investigation is Hyperion doing? Now remember, Hyperion has to do this investigation per this order we approved. And even more, Hyperion workers have to know when these people are smelling odors because they know what's occurring at the site. So they correlate what's occurring at the site and when they smell the odors with based upon the complainant. And then we can correlate where at the site we may be having the odors. Because remember, the whole place sometimes it can generate these odors. It's not a location in there, except for maybe the administration buildings that will not generate sewage odors. That's what they do. They treat sewage. So when we're looking at these logs, ladies and gentlemen, we are dumbfounded. And when we interview the complainants and they're saying they've never been contacted, it looks strange to us. And I've inquired with Hyperion Treatment Plant, shift suits, why, what's occurring? Why are we seeing this? And they just like, I don't know. Excuse me? The answer was, I did not know, is what I heard. Thank you.
Thank you. Okay, so you said that you've seen in the records various times that the doors are opened. Can you give an estimate of how often you see that doors are open in these logs?
Well,
over your review of records over the last 6 months, like, is that common?
I would say for the last 6 months, I've reviewed over 100 complaint logs that was generated by Hyperion Treatment Plant operators. I would say every single log shows doors open. Sometimes the log does not even designate if the doors are open or closed, which is also against the law per their Title V about record keeping. So I would say over 80% of the time, the records that I review show violations.
Okay, and you also said that you have observed doors open yourself, when you're on site. How often would you say you have observed the doors to be open when they're not supposed to be?
Well, I see the doors open when I'm driving through the plant. I cannot confirm if the doors, if they are loading at the time, unless I talk with the shift steward. So I'll say I see the doors open at least 90% of the time when I drive through Hyperion Treatment Plant and perform surveillance. Later on, when I talk to the shift steward, I then confirm whether or not they are actually loading anything at that time. And normally it is either yes or no, but the bulk of the time it's been a no.
Okay.
It's not, so in other words, if they're not loading and the doors are open, that's still, even though it's not a direct violation, the whole building is odorous. So you're gonna get faint odors from this building, whether or not the doors are open or closed. If the doors are open, you're gonna get even more odors from this building.
Okay.
So, yeah.
Okay, and so this violating this condition, does that seem to be a cause of odors in the community? You said if the building will be odorous. Can this be a cause of odors in the community?
Yes.
Okay. And are you aware if Hyperion's taking action to correct this problem of failing to keep the doors closed?
Well, like my previous colleague indicated, they do use a odor fan that sprays perfumant. Now remember, these buildings are on the west side of the facility. So, and the perimeter fence line is on the east side. So I've driven down that road and I've never detected any perfumant odors from the fan that's at the truck loading facility. Now they do have fans at the digester. They have some fans over near the primary. These fans move around, but the ones that I've seen in the last 2 weeks have been at the south end of the truck loading facility, and they were operating, they were blowing. And I did smell the perfume, a mint sort of type of odor that you get. But it doesn't really do a whole lot against the odors from sewage. That's overpowering. That odor, these fans are not going to be able to compensate.
Okay, and aside from the odor fans, are you aware if Hyperion has acknowledged the problem of keeping the doors open and or have they acknowledged that?
Well, I've seen on their records, the operator, when they're walking around doing their own investigation, is identified the doors are open and he shut the door, or he had the door shut. One log said the doors were broke and we couldn't shut the doors. Another log said that the ceiling was falling in, and so we had problems with the loading facility. So, I mean, it's a problem. And it does not look like they're trying to resolve it.
Okay.
This is continuous.
Okay. All right. You also mentioned about contacting the complainants. You mentioned in your review of complaint logs, it doesn't appear that Hyperion is contacting the complainants, correct?
Correct.
Okay, and that, let's see, and what about providing written reports after their investigation? Are they doing that, if you know?
Over the last 2 weeks, I've interfaced with maybe about 10 complainants. Out of the 10, you've probably heard at least from 5 of them already, at least. It appears that Hyperion has started to send the written that's due within 96. Definitely they did indicate they did receive their logs for that day. But ladies and gentlemen, I've been auditing Hyperion Treatment Plant off and on for 15 years. In the last 10, I was assigned as lead inspector to this facility. So when 2021 occurred, the major spill, I was assigned the plant from that going forward. I was assisting an inspector then. I've been on this plant since then, dealing with order of abatement issues as well as complaints. ladies and gentlemen, let me make it real clear. Yeah, the plant still suffers from trying to comply with the order of abatement. And definitely, they are having problems getting written documents to these people. And even the documents that they have sent are not in compliance with the order of abatement. It has to show you contacting the particular complainant. We don't even know if Hyperion treatment plant is even going into the community, according to these logs. Now, maybe they can produce something that shows this, but we've not been able to establish it. And talking with the complainants, they will reinforce what I'm saying. They're not contacting these people. So how are you doing an odor investigation? I know, I've taught inspectors how to do odor investigations at Hyperion treatment plant. And we would never do anything like that. We always have to contact the complainant.
Okay.
And when you're looking at these records and logs, they're misleading.
And the failure to provide written reports, what condition are we referring to?
We're referring to 1E.
1E, okay. And what you said that complainants are telling you they aren't contacted or not receiving the reports, and what is the frequency of which you receive that complaint that they're not receiving contact or reports?
Again, as I said, we're just keep it simple. Let's go back at least the last 2 weeks. That means the last 2 Saturdays. I've looked 15 complaint logs. I've contacted at least 8 of those complainants. All of them are saying they've never received the summary regarding these particular complaints that they phoned in this part of July. Now remember, they did get a series of documents that I've not seen. They got something around the 17th or the 18th of July, but I've not seen those documents, so I don't know if they comply with the order of abatement or not. But previously, I did see a document that was sent to me by a complainant. They alleged they got it from the communication center at Hyperion treatment plant. I believe Ms. Shelton, some person with communications, I guess. And it was like an Excel spreadsheet, and it still was missing everything that should be on there. It's almost like they are keeping this information away from the complainants. Is what I see.
Okay. Let's see. And when have you raised the problem, the concerns about the written summaries and the contact to Hyperion?
Yes.
And what is their response?
The shift supervisor told me that after they do the investigation, they send them to communications or community affairs or some department, Ms. Shelton, some lady, and she's supposed to send them out. Is all that was told to me.
Okay. Okay. Are you aware of any actions that Hyperion is taking to maybe correct these problems?
No.
Okay. And have any NOVs been issued for violations of these conditions that we discussed?
Yes.
Okay, and when was that?
I want to say that was July of this year, I believe. Let me check this one. Yeah, June. The violation date was April the 16th, and it was served in June of this year.
Okay. For violations of
Failure to provide written reports, condition 1EX, failure to have the doors to the truck loading or unloading facilities closed regarding condition 41. And let me also add that according to this order of abatement 1D, they're supposed to investigate the complaint within 1 hour. According to their records, it shows the majority of the time that they start their survey, I guess their investigation, and the survey is normally started within an hour of them getting the complaint. I will state that for the records. It does show on some of the records that they do start the survey, but it doesn't show when they actually talk to the complainant about their odors that they phoned in.
Thank you. I don't have any further questions at this time.
All right, it's 11. Why don't we take a break? We normally do in the morning, 15 minutes, and then we'll come back and we'll pick up again. D, we're on recess for 15 minutes.
No, that was just.
Don't worry, it's our secret. That's what I get.
subcommittee questions on the break?
No, thank you.
Hyperion, your turn to examine that witness.
No questions for this witness. Thank you.
All right, the board questions, I'll go first. Chair's prerogative. So Mr. Haynes, with respect to the unmet conditions, you know, we certainly don't want to have orders that can't be complied with or unrealistic. Is there anything that's not being met condition-wise that you feel maybe it's too harsh, or that there should be some alternative looked at that might facilitate compliance but still yield the effect the district wants?
If we're talking about the notifying the public or the complainants, I think the board and the agencies have gave Hyperion Treatment Plant a very easy approach to do it. I mean, we've mimicked it on what we do. So to answer that question, if we're making reference to that, I would say no. I think they just need to follow it. We've given them everything. Again, we've given them a template of how we do our inspections to authenticate the odors. So I would have to say no for that particular condition. And in regards to the truck loading facility, you know, the plant is very aware of these conditions. This is nothing new. However, I think they do need to hold their operators accountable. That's something that they can definitely do. They can hold those operators accountable because the shift soup is normally in the control room. Now, if there's an incident, and I'm saying he because it's normally men that are shift soups, they'll go out to the field or they'll go out to the location where an operator has phoned in a concern or a maintenance issue. But for the most part, the shift supervisor is around the control room. So we have a series of operators that are at these facilities or buildings that are operating the plant. And so I think we just need to hold them accountable, and their names are on these records. I mean, I know who they are, meaning in there by name. I never push up to interview them or interrogate them. I normally just handle that through the the shift supervisor or anyone that's in the APC group. Mr. Sadehi, if he's available, Miss Sine, I think she was here. That's normally the people that I know, and then they've hired several environmental engineers. I call them junior engineers because they report to Miss McIntosh, who's a primary engineer at the plant. So they can hold these people a lot more accountable. But in regards of other formats that they can use to make it easier, I think this is about as easy as it comes.
All right. And now condition 1G about the written reports that refer to the 1E complaints, et cetera. Is it that they're not getting you those reports weekly, or that they're incomplete since they haven't done the complainant outreach in the first place, or a combination thereof?
According to the records that I'm seeing, they're completing the investigation. It's just that their investigations appear that the operator is not actually contacting the complainant when they get in front of their house or the location where they phoned in the complaint from. But otherwise than that, I've already stressed the Hyperion Treatment Plant management numerous times just to send out the complaint log that their operators complete and get it out within 96 hours. Really, the only thing they have to do is, since the operators already have it, I'm not sure why they have to send it to other departments, but I understand that they do. But to me, it'd be easier just to scan these, put it in a database, and then within 96 hours, press send and send it out. I mean, they have the phone number, they have the email address to these people, these complainants, they got everything. So why they have not done it is still unassured to my agency and me.
A couple of items that have been outstanding from the monthly reports, and I want to see if you could comment on them. I'm looking at the June 2024 monthly report, and it talks about condition 48C, trunk sewers monitoring equipment. And the report says approval for use of the Eagle 2 was submitted on 1/26/23, but we did not get a response. Are you aware of what's going on in that condition? Why there's been apparently no response from AQMD, or what's going on with that condition?
It was my understanding that we did approve that equipment, but to answer your question directly, I was under the impression that we had approved it, but to answer it, no, I don't have anything more to add on that.
Okay, yeah, it does say the equipment was approved in November 22, but approval for use of it was submitted on 1/26/23. We did not get a response. I'll ask Hyperion about that. And then the other one that caught my attention was item 4, dealing with the Teledyne units. And basically, ever since December, every month, it basically says waiting for clarification from SC AQMD on approval of location. And that comment has been repeated month after month after month this year. Do you know anything about that condition and what approval, if anything, is lacking from the district?
No, I do not.
Okay. All right. My other, I guess, philosophical engineering question for you, if you can, is are the district and Hyperion designing a system that would work once everything's been completed when there's a normal flow, 150 million gallons a day, but that when there are breaks somewhere external, if you would, the 400 million type breaks, that they won't be able to handle it? And it's like designing for a 50-year flood, except this case, it seems like these breaks happen more than once every 50 years. So are we kidding ourselves if all they're designing is something that works when there's 150 million gallons, but if every 6 months there's one of these exogenous breaks, it falls down, and then you've got months of cleaning up? And because what caught my attention was the February break, they were still cleaning up residue and odors 5 months later. So you understand my question? Do you have any thoughts about that?
I know permitting has been involved. AQMD permitting has been involved in talking, I thought, back and forth with Hyperion. I am aware, well, it is my understanding that AQMD permitting is not going to amend or modify any of the existing Title V's until I guess they get out of this order of abatement phase. But they have been in contact with Hyperion Treatment Plant regarding some of these same concerns. And then I believe in the order of abatement, Hyperion Treatment Plant did hire a consultant to do an assessment of their odor controlling equipment and their operations. I'm not clear how detailed my agency looked at that, at least enforcement and compliance looked at that. I think it was mainly sent over to permitting, and I thought also sent over to special monitoring, who approved these, who agreed to these locations that Hyperion decided to set the monitors at. But remember, Hyperion Treatment Plant has a backup monitor on site. So when my colleagues were telling me of this incident about the monitoring system going down and it had problems, just replace it with the monitoring system that you got on site. Replace it. Just move that one out and put another one in. Very simple. Stored in the warehouse, which is right on site. But it appears they're not. The last time I saw it, it was in a box though, so I'm not sure if they unboxed it. But the last time I talked with the plant operators about that, they just said to me that management decided to just correct the just follow the equipment that's up there and just get Montrose in to do an investigation and make some changes. That's all I have on it though.
All right. No other question from me, Ms. Verdugo Peralta.
I have questions. Thank you. Mr. Haynes, thank you again for all of your service. 15 years is a long time to be looking at one facility. So I appreciate all of the work you've done out there and your response to the public as well. But I wanted to try to understand this. Closing of doors doesn't seem like it's a very scientific, technically difficult thing to do. Have you had any discussions with people at Hyperion why they're not closing those doors?
Well, yes, I did. And one time they informed me, which was maybe about last month, and then also on their logs, it confirmed it, that the doors were broken. In other words, the electronic system to shut the doors were broken. So they couldn't shut the doors.
And I'm like, guys, this is a violation of our Title V. It's a violation of your order of abatement. And they're like, well, we're working on it. We got the ceiling of the building collapsing, according to their records. Ladies and gentlemen, the ceiling of the truck loading facility is falling in. Now, I'm sure Hyperion should be able to explain that. The operators were unable to explain it to me when I was there.
How long have there been problems with the doors not closing?
Off and on, I'll say, at least since January.
Of this year?
Of this year.
And not prior to that?
I mean, I've seen it prior to this. I mean, how far you want me to go back? I can go back to 2020 with this facility. If we go back to 2020, I've seen it a lot.
Mm.
You know, I've seen it a lot. I mean, if you look at some of the older Title V violations we've issued under Title V, some of that's actually on there. So this is nothing new to Hyperion Treatment Plant. Now, and it's nothing new to their operators.
And how many sets of doors are we talking about?
Well, remember, it's like a garage, looks like a big garage. So you have two in the front, then you have two in the rear. But we're speaking of the ones in the front are the ones that physically are the ones that do all the closing. The ones in the rear also close, but the ones in the front are the main ones where you can, you know, driving by or stopping in front of there, you can see right in there.
Mm-hmm.
So, but I don't confirm that until I meet the ship supervisor and then until I look at their logs. And I, you know, inquire with them and they'll send somebody over there, but I tell them I'm gonna let the inspector, the sector inspector follow up, meaning Mr. Inspector Lee or Mr. Bucamp. But otherwise than that, yeah, I see it a lot.
And one other question I had, I asked the other inspector, Montrose is a third party to Hyperion?
From my understanding, correct.
Okay, and do you know who pays Montrose?
According to the shift supervisor, LA Sand pays them.
Okay, thank you very much.
Dr. Abraham?
Yes, I have a few questions.
No problem.
I'm listening to your testimony and I am concerned that there's just a negligent, if not willful, refusal to comply.
Well, young lady, if
So-
you were to read my NOV reports, it will show willful and intent.
And I appreciate that. I'm also looking at the record here and I see so many orders from us to abate the problems and to find solutions. I'm not hearing that. So my question for you is, has a list of general best management practices been developed since January or February? And has there been an assessment beyond what you've testified to already of odor control mechanisms? If you know this door is not going to work or it has problems, why isn't there another plan? Why isn't it repaired? Why isn't there something proactive to address the problems that are associated with the odors for the residents in this area? Maybe you can answer that if you've asked those questions and if there's been a response.
Well, remember, since the order of abatement was adopted, they had to do series of investigations, surveys, etc. And they do have a plan. Remember, that plan was implemented and that plan was developed in 2022, 2023. It has not been updated to address the 2024 problems that I've seen. So to me, to you, yeah, I think they do need a different plan now because evidently they're allowing the work to occur with doors open. They're allowing the work to occur and no one is telling complainants about the odors and where the odors are coming from. So yeah, I think they do need an updated plan.
Is it your understanding since January of 2024 that they were to also come up with an on-site assessment in addition to the one in 2022 and develop a plan?
It is my understanding that they were supposed to. I think they did send an update. You can probably cross-examine them when you're there on the stand, but I've not seen the full copy of it because it didn't come directly to me. It came to my department. to address some of these things. But as I said, it's normally written in their monthly reports of how they're addressing these things, but that's all I
I'm
have.
moving beyond their written report,
Mhm.
if you will, to what you're observing now. It's one thing to have it written in a report. It's another thing to actually implement what's written in that report to address some of these problems. Do you see evidence of implementation?
No, I do not.
Thank you.
Thank you. Could we mark the exhibit we just got, the ex parte minute order, or do we need?
Sure. What he's referring to is it was referenced earlier, the ex parte minute order from the incident in February. So I guess this will be a district exhibit, Madam Clerk. The number 10 then?
So it's Y or?
You're right. Y, huh?
Y.
Okay. Thank you, Maha.
Sure. And I think Mr. Haynes could, well, still morning, good morning. It's always a pleasure to hear from you.
Good seeing you again.
Yeah. You, I think, mentioned the ex parte minute order, and you have you reviewed that minute order?
I looked at it when it was approved, and then I also went out on a day to verify compliance with the ex parte minute order.
Now, when I look at this in the first page, maybe the fourth paragraph, they anticipate similar weather events will be occurring to the upcoming winter and possibly early spring season. NOAA has predicted it, so this is going to recur. I mean, in 2021, the storm caused most of the problems that we were dealing with, and then it's cleaning up. And again, it happened this year, at the beginning of the year, and looks like there's going to be continued because of the change in weather and the atmospheric rain we're going to be getting, which has been predicted. So I don't see anything in the order modification to address those, I think the system is designed to enter 500 MGD, typically 500, and they may get higher or lower, but when it exceeds 500, that's why this emergency situation, they wanted to move that to D, but it's going to happen again. You're going to have sludge again in those things, and they have to clean it. And during cleaning, it's going to again, if it's not properly controlled, it's going to cause odor. So it's going to go more frequently if the weather pattern continues. So I don't see anything in the order modification, except for just changing the status, when the order expires. But I don't see any modification to address this issue, because that's primarily what's driving some of the problems they have. Because they have prepared ABCD, and when they pushed it to D, it was still under repair. So that caused the problem, but they had no choice because there was a huge amount of influx of influent. And so my question is, should this order be modified, in your opinion, to address this kind of situation that will occur again?
My professional opinion, I would say yes.
And what kind of conditions are you?
I would say the similar conditions that they're asking for in the ex parte, that it be possibly moved into the order of abatement, because it's going to occur with our climatic issues we're having. And atmospheric rivers appear to be standard every year. And when it does, it increases the chances that Hyperion treatment plant and other sites to get flooded. This site cannot get flooded. We can't get this overflow in there that they can't handle. If not, they'll pretty much be doing the same thing, just redirecting it to, other batteries. But, is the other batteries going to be able to hold it all? Again, just like what happened in 2021. Remember, in 2021, they had to put the waste in clarifiers. They had to put it in other areas. So I agree with you, my professional opinion. I have not had time to really sit back with my unit, my management, and legal to discuss possibly an amendment to this, but this is something that is going to occur. And in case point, they brought this to my attention before they even filed this, talking with one of the shift soups. He was concerned that it may happen. So I told him the only option you guys have would be at this point a variance to put it in battery D. And this was before this issue even occurred. He was concerned about them having this overflow. And I told him then, the only option you guys got right now is, since AQMD is not really amending any of their Title V permits, the only thing they got is put it in go for the variance and ultimately may put it in the order of abatement. But when we were talking, we were not talking about amending the order of abatement at that time. I remember I was speaking to a HTP representative, ship supervisor. So they have their finger on the pulse, meaning the ship supervisors are aware of a lot of this, but on their side, getting it from the ship supervisor up through their management and it's requesting or showing up in the order of abatement or an ex parte is on that side.
Now, an order of abatement has typically will have a finite date. You cannot extend it forever.
Right.
So there has to be operational changes at the facility so that, to address the long-term solution, not continue the order of abatements to address this situation. Because this particular one, the ex parte expired March 22nd of this year, 2024.
Right.
Okay. Now we heard a testimony from the inspector, and he was there when they were doing the cleaning. There was orders. But I do see condition 33, I believe, that says that they have to be vented. 33 says they shall install temporary enclosure while they're open for refurbishment, but the temporary enclosure should be vented to odor control equipment with sufficient capacity to have a negative air and vent it. So this was when they were doing refurbishment, but is that something that they're not doing now when they do the cleaning?
Well, I'm not seeing any refurbishment, quote unquote, at least identified by their ship operator in a while. But I will agree with you on the fact that they do need to handle it differently, and as well as they may need to consider changing this order, requesting an order of abatement and putting it in there. But yes, I am agreed with you. This order of abatement cannot stay forever. It's not a permit. So this order of abatement ultimately will expire, and when it does, we're gonna go back to a plant that currently can't seem to comply with the current order of abatements that we got going on right now. And it's gonna possibly get worse if we have these storms. I'm not a meteorologist, but my last 3 years at the agency, we've seen Hyperion treatment during these wet events. Yeah, their inflow has risen. Now, again, it has not exceeded the 500 theoretically, except on that day that we were investigating them in February. But yeah, that's going to be a long-term problem.
Now, on the I'm looking at condition 41, but truck entry and egress doors shall remain completely closed, but it except during breakdown. So when the doors, you say, broke down, did they call a breakdown or?
Not that I'm aware of.
Okay, but those areas are vented to control systems, are they not? So scrubbers?
Yeah.
So they do have negative air, and but
the doors have to be closed for it to work.
Right.
Well.
And so when you observed it and you say the doors open, were you seeing loading and unloading, or
the times that I've documented it, they were not loading at the time. But again, you're dealing with an odorous building. So whether or not they're loading or not, you have odors coming from this building. Now, whether or not these odors are getting past the eastern perimeter and out into the community, there's a probably 50% chance those odors are contributing to what these other inspectors are confirming on those 402s.
So are you saying that even with the scrubber operating, but with the doors open, even, I'm sorry, when they're not loading or unloading and and the doors open, there is a potential for odors from that.
Yeah, you still get every now and then you can get a faint odor standing right there in front of that building, even with the scrubbers on.
Have you taken any readings, which H2S or Jerome monitors or anything to
No,
indicate
I
that?
haven't, but I believe when they conducted the 2023 Title V inspection, the one that Mr. Inspector Lee spoke about, I believe they did some external monitoring at the site. Now, I don't know if they did it in front of the building because I did not participate in that Title V inspection and site investigation.
Now, we've seen not a similar facility, but other operation where they use air curtains to prevent the movement of if it's warrant, from inside going outside. I'm not recommend that not knowing the severity,
right.
If it's down in there's no readings to substantiate because it might not be an effective control if do you think an air curtain?
I think an air curtain like what we see in some of the chrome facilities would definitely help.
When the doors are open?
When the doors are open, yeah, it would definitely help.
Okay.
Anything to prevent odors or potential odors coming from this building, I think Hyperion Treatment Plant should at minimum investigate, if not implement.
Okay. Now, the last question, you presented somewhat of a situation where they're not complying and so forth, but why isn't there no proposed amendment to the order to tighten up the order to make sure that they can?
Well, I just say we recently lost our manager. She retired. So I did bring that to her attention a couple of months ago, and I thought it was going to elevate up a little bit, but I'm just going to say it was probably that we just lost our manager, the toxic unit manager retired. So a lot of that is now being filled in by, I would say, as our AQACs. So I'm almost sure going forward, we will bring this to their attention again. But again, I'm not saying that as an excuse. I'm just letting you know that was probably what happened because I was reporting a lot of my findings directly to my manager and my supervisor.
So there were some concrete proposals by staff to your manager?
From the inspector level to the manager, yes.
Okay.
Yeah.
And or you don't know what?
No, I don't know. Again, she retired, and I'm not sure who's going to pick it up. But I'm almost positive after today's hearing, we will regurgitate that information back to management and see what we can do.
Because we asked to extend the order, but we are not seeing any remedy to further reduce the complaints we're getting. So we're going to extend it, and then we're going to maybe sunset it in January of next year, or I'm not sure, because we cannot keep continuing this.
Right. I
But
understand.
we need to know what if compliance has other suggestions, and if permitting is going to take after the order, because they don't want to issue the permit and
They can't
until
legally,
the order is
resolved.
So so if that's the case, we should sunset the order if there are some concrete proposals by permitting or compliance to make modifications. So we need to know that before we sunset the order.
Right. I understand that. Well, remember that they are the largest wastewater treatment plant that I've ever audited, and they're the largest wastewater treatment plant this side of the Mississippi. But they're also the oldest treatment plant. So if I go to some of the other treatment plants that are under my jurisdiction, it's night and day on how they're handling some of their issues compared to this one.
I did look at there was a December 22nd Hyperion odor control study and some of the control measures that they proposed. I think most of it, I think, is incorporated in the order. I can't say for sure, but they did identify many areas that it seems to be still problematic that is causing, like the cleaning, which they did say to minimize the fugitive emission, that to look at leaks, and have have high precision hand analyzer around and get readings around where the buildings are and so forth. I mean, we are doing perimeter monitor, I mean, not, offsite,
Right.
but not around where exactly where the source are. And I know there are conditions for looking at the scorbus and so forth, but okay, let me ask you this, because it says that HWRP should review standard operating procedures for maintenance and cleaning of treatment areas, example, primary tanks and loading and unloading of chemicals. This seems to be some of the areas that were pointed out by you and the previous inspector. Do you know if they have reviewed the standard operating procedures? Has they been revised?
Well, I've not talked, I would say in the last 2 months, maybe 3, I've not talked to anyone higher than the shift soup at the plant. And if I did, it was an email, someone sent me something, I said, thanks. I am not sure that the information that you just read out on that study was even actually shared with the plant operator, meaning the shift supervisors. It took them document. And he said, no. He's never even read the complaint log. So he doesn't even know what the operators are finding when they do walk the plant. So I think between that, what you're indicating, Hyperion treatment has to do a better job of internal talking and resolving these problems. If not, we're going to continue to see it.
Last question. I saw in one of the complaints that they were frustrated because the AQMD is not doing after-hour surveillance or weekends. But I heard from you, you were there Saturday and maybe Mondays. But I'm assuming there's still after-hours system in place for
there's
responding.
an after-hour system in place, but it is also getting those inspectors out. It's easy to get them out. I would say when I was responding all the time, 7 to 8, but when you get those calls at 11 o'clock at night and 12 midnight saying we got over 8 complaints, we need you to go out there. It is an individual responsibility. Some inspectors say I can go, some don't. But AQMD does have, excuse my French, an excellent response scenario plan in place to respond to these. We just are hoping that Hyperion, since their operators are on site and we're not, when a complaint comes in, they are the likely party to investigate and find out the source and the solution. AQMD does show up. AQMD will go into the plant, but you also remember, we're limited on what they tell us. I mean, yeah, I'm familiar with the operation, but if they say, that they're doing primaries and I don't see any problems with the reactor areas, then I'm gonna follow them on the primaries. So we're at the limit of them, meaning a Hyperion treatment plant, and their understanding of the plant and what they want to disclose to us.
My question really is that AQMD has a presence after hours, and they should not call in, regardless whether they call Hyperion or not, right. Because if there's sufficient amount of complaints, depending on even if it's 2 a.m., this after-hour supervisor will assign somebody to respond. Am I correct?
Correct. Three complaints in 1 hour, the after-hour supervisor will normally dispatch, unless it's a breakdown. And if it's a breakdown, they normally, get the inspectors out right then and there.
Okay, no, thank you. I appreciate it. No further questions.
All right. I see one more question, Ms. Rodrigo Peralta.
I'm sorry. What I want to do here is, I don't want the public to think that we have just been sitting back, holding our hands and being concerned about this issue. We received a request for a variance in February because of the atmospheric river that was going on, and there was spillage. And I responded to that as the chair at the time with the ex parte minute order. But that minute order within the document has 21 conditions. And even just looking at what was written, it's number 6 per your testimony was not followed. They have not notified the AQMD within an hour. Number 7 has not been followed through because of the loss, or I should say, not maintaining continuous records of the flow readings. And most of all, number 11, we were under the understanding. We had an understanding, at least this is the information that I received, that once the flow, the primary clarifier battery D has occurred, once the flow to that battery D, the petitioner was going to install and operate at least one additional continuous AccuLog H2S monitoring system, which was to be located between primary clarifier battery D and residential receptors and within 10 feet of the primary clarifier battery D. Do you know if that occurred or not?
You should do for that documentation on that, and today I've got previous.
Okay, thank you.
All right, thank you, sir, for your testimony. Appreciate it. That's your last witness, Ms. Chavez?
Yes.
All right. Start for you before like 12:30, but we can start your first witness.
Yeah, sure. Respondent would like to call Joshua Melendez.
Good morning, sir.
Good morning.
State your name and title and spell it for the record, please.
Joshua Melendez, JOSHUA MELENDEZ, and I'm a member of the Community Outreach Team for LA Sanitation and Environment.
I believe you stood and took the oath earlier.
Yes, I did.
All right. All right, Ms. Hoppestein, go ahead.
Okay. Mr. Melendez, we heard some public comments and testimony about some of the concerns with providing written summaries to complainants when they call in the Hyperion system. Are you familiar with that condition of the abatement order?
Yes, I am.
And you're familiar with the 24/7 hotline complaint procedure, correct?
Yes, I am.
And you said you are a member of the LA San Community Outreach Team?
That's correct.
What is the community outreach team's role with respect to the odor complaints hotline?
With respect to odor complaints hotline, we receive the reports or findings from Hyperion staff that from all the complaints or any complaints made to Hyperion, we take that summary of findings and send out the written reports to those complainants.
So you and others in your group are responsible for actually finally responding to the complainants regarding the findings of the odor complaint. Is that correct?
That's correct.
Okay. I would like to walk through a little bit high level the process of what happens. So when someone calls the hotline, what happens?
When they call the hotline, from my understanding, a Hyperion operator would take the complaint in and pass it along to an appropriate staff member in Hyperion to investigate the matter further. After they complete their investigations, they will send us, the community outreach team, the summary of their findings.
And you said that someone at Hyperion starts an investigation. Is it your understanding that that investigation begins pretty close in time to the receipt of the complaint call?
Yes, from my understanding, that's correct.
And is it your understanding that it's within 1 hour of receipt of the complaint?
From my understanding, yes.
And you said that the control room's investigation goes on after that. Once the control room's investigation has concluded, what happens next?
They would send the community outreach team an email of that report of their summary of findings, confirming that they had sent it to us, and then we take that information and start with our process of sending it out to the complainant.
And can you describe what you just mentioned, the process of sending it out? Do you kind of track it? What happens?
Yeah, so what we do is we take whatever information is posted on the findings, we create that a separate kind of template report, input just the information verbatim from that summary of findings. And then we add that particular information, all the information such as the name of the complaint, the date of the complaint, time, all relevant pertinent information on a complaint log, which I believe we send to AQMD.
And the written report that's provided by the control room, do you send that out through the method that is requested by the complainant within 96 hours, as is mandated by the abatement order?
That's correct.
Okay. And you said that this is tracked on some sort of tracking document? Okay. And that tracking document is sent to Hyperion, is that right?
That's correct.
And you said earlier that your understanding is that it's sent to Hyperion to be included in the weekly submissions to the South Coast AQMD?
That's correct.
And again, to confirm, that document reflects the date and time on which the complaint was received. And on the other half, so that's on the left half of the page. And on the right half of the page, there is a denotation of whether there was a callback, the date, time, and manner of the written response that was sent out.
That's correct.
And that can take the form of email, text, or mail.
That's correct.
Okay. And did anyone from Hyperion ever relate to you that any AQMD inspector or staff asked any follow-up questions regarding the tracking sheet that we just discussed?
Not that I'm aware of.
And do you know if in addition to and within the confines of the abatement order, Hyperion does any kind of proactive outreach to the community members?
Sorry, just to clarify, outside of the order of abatement? So outside the order of abatement, we do MailChimp campaigns or notifications to the community. We got some feedback, and what we started to do, a new process on the MailChimp, is to identify the type of communication we give to Hyperion or to residents of the subscribers. Right now, the last approximation is around 3,000 have subscribed to this particular distribution. And what we do is we have color coding as well as an at a glance of what it is, the type of communication we're presenting to them as it's presented to us by Hyperion staff to relate to the community.
Thank you. I would actually like to go through the last weekly submission to the South Coast AQMD about these complaint logs, the tracking sheet that we had just discussed. So this is the document that you referred to earlier that's sent to Hyperion for submission to AQMD, correct?
That's correct.
And again, the information contains the name, date, time of the complaint, and any follow-up that was performed, including the time, date, and form of the written report that was sent out.
That's correct.
And earlier, we heard some testimony from Ms. Tamara, I cannot say her name, Kuchowski, regarding her complaints to Hyperion. She testified that she never received phone calls and emails. Do you remember that testimony?
Yes, I do.
I would like to turn to this weekly submission to AQMD and go through just a few of the entries.
Just a second, is this document an exhibit? And if so, not, do you want it to be? Or how do you plan to handle this?
Oh, no, it is not an exhibit, and we don't intend to submit as an exhibit.
All right, we'll see where this goes. But I mean, if you're contradicting what someone else said and you've got something in writing that contradiction, we should probably be aware of it.
We can submit it if need be, but we can certainly see how it
Okay,
goes.
continue for now. Thank you.
So let's just start with an entry let's just start from the last hearing. So there is an entry here for a complaint by Ms. Tamara Kuchowski on January 31st, 2024 at 10:27 a.m. Do you see that?
Yes, I do.
Okay. And it looks like on the right part, it denotes the date of February 1st at 1:30 p.m. and a column that states a callback was not required, and another column that states emailed report. And that time I just mentioned and date February 1st, 1:30 p.m., that would be the time that the email report was sent out?
Either then or roughly soon after that. It could be either both, or as is such, one of the members had received that complaint. This is when we're going to respond to that and do our work.
And where it says emailed report, you would have, or your group, the community outreach team, would have a record of the email that was sent out, correct?
That's correct.
Right. And we just looked at January, so we can look at a February. There's a February 24th, 2024 complaint at 7:30 a.m. from Ms. Tamara. And it looks like, again, the date on the right side is February 24th, 11:55 a.m. A callback was not required. Emailed report. Would you have a copy of the email report referenced here?
You should have a copy.
Okay. And it looks like there is another entry, March 11, 2024, from Ms. Tamara Kachowski, 2:30 p.m. complaint made. And then March 12th, 8:35 a.m. emailed report. You would have a record of that email that was sent out.
You should have a copy of that.
Okay. And earlier, Ms. Tamara Kachowski testified that she received responses for about 30%. Would you agree with that figure?
I would need to look further. I've only done a spot check up to 2024, about 90 entries, but our team would actually need to take a look at that further.
And I mean, I don't want to belabor the point, but having gone through this document, would you say that it looks like it's potentially higher than 30%?
I could not say one way or the other, to be honest.
Okay, thank you very much. No more questions for this witness.
Afternoon, please.
Good afternoon, sorry. By 8 minutes. Okay, you mentioned this tracking document. And where is this tracking document located, or where can somebody from AQMD find it?
As far as AQMD, it's part of a weekly report sent by Hyperion. That's as far as my knowledge, because we send it off to Hyperion. Hyperion sends that weekly report to AQMD.
And who's responsible from Hyperion to send it in the weekly report?
That I'm not fully aware of.
Okay. And you said that a couple of those logs had callback not required. So who would check that box, callback not required?
Usually the complainant, is from my understanding.
Well, they wouldn't check a box on they wouldn't check a box on Hyperion's records.
Either that or it would be like a reference as part of a comment that they would not need one. That's from my understanding of how that would go.
Okay, because did you hear the testimony saying that she's always requested a callback and has never received a callback?
I did.
Okay, but you're saying it would be the complainant who is checking that box, not necessarily the operator from Hyperion receiving the call?
Typically, yes. It would only be from the complainant.
Okay, could it be the Hyperion operator receiving the call, mistakenly checking that box?
I would not be aware of any of that.
Okay, because you don't get the complaint log or investigation until after the operator's already done with it.
That's correct.
Okay, so you're two separate teams.
Correct.
Okay. And then have you seen the weekly reports that include this tracking sheet that you discussed?
I've seen last week's, but I'm not very familiar with many of them, or I'm not privy to that.
Okay. All right, I have no further questions.
Any redirect?
No, thank you.
Board members, questions about the pound?
Yeah, Mr. Melendez, just on the MailChimp, do you also get reports on the H2S monitoring exceedances?
Not us personally, not community outreach team.
Who gets that, and do you know?
I'm not fully aware, but I'm assuming it would be Hyperion staff would get that.
And they don't go to you to disseminate that on a certain date there was an exceedance of the H2S or so forth?
I'm not aware, at least from my position.
From your position, okay. And this format, that report that you sent to AQMD, the weekly, that's in the Excel format we heard about?
Can you repeat that question?
Is that the Excel format we heard?
Yeah, so the Excel, we provide an Excel sheet of this complaint log that we have, and we send that to Hyperion and
to
then
forward to.
Exactly.
Now, also sometimes what percentage of people who call in the complaint are anonymous, do you know? And hence won't get any feedback?
Anonymous, I'm not aware, at least I haven't detected anything that's anonymous per se.
Okay. Or okay, I mean, they always identify who they are and where they're located?
From my spot check-in, it seems like every complainant has identified themselves.
Okay. Okay, no further question. Thanks.
Thank you.
Dr. Abraham?
Have there been complaints from within the organization, from staff members of Hyperion or employees?
Not that I'm aware of. I haven't heard
Do
of
we
any.
know if anything's been reported to HR or some sort of occupational or safety or health entity within the organization?
I'm not aware of that.
Is there a reason why you're located kind of outside of Hyperion and why Hyperion doesn't have a local kind of communications group to deal with such a serious issue that has been going on for so long? It seems like they're, just kind of tossing the ball further down if possible. Is there a reason why y'all are managing this rather than a team at Hyperion?
That I'm not aware of. We're just happy to help LA Sanitation wherever
Are y'all
we can.
managing a lot of other projects besides Hyperion as well?
Yeah, we're assigned to other sewer
How many other
projects.
projects are you working on?
I want to know off the top of my head, but a few hundred of different types
Do
of.
you feel like you have the appropriate resources to actually adequately respond to how serious this concern is, given the concerns from the public?
I believe so.
I really do want to better understand how I'm hearing very different things from different people today, from the public, from AQMD's expert witness, and from you. So you are reaching out to the complainants. The complainants are saying, I have not been reached out to. Can you help provide an explanation as to why that may be the case today, why we're hearing different things?
That I can't fully describe that, especially since I've only did a spot check of about 90. From our recollection and records, we do as much as we can. We do have some complaints as far as mailing. We did hear about that there's some mailing that's been done that maybe they have not received it, but we've been doing work as far as to have documentation to show that.
Is the communication ever multimodal? So you'll send an email as well as a mail, as well as a phone call?
At times, if requested, but we typically go by the
Who would
preferences.
request that?
The complainant may
Would
request
say,
it.
please email me, please mail me, and please call me back?
Yes, as far as that, but I haven't seen those specific.
Do you have an ability to run a report on which of your MailChimp emails have been opened and the number of people that have viewed them?
Yes, as far as that, I would not have the permission to do that. We would have to ask through LA.
Has anyone run any of those analytics as far as you're aware?
Not that I'm aware of.
Okay. And that'd be somebody above, like, within your same department? Is that correct? That
Maybe
would
not,
have the
not directly
ability?
our department, but yes, someone above me would be able to see the MailChimp statistics.
So you're with LA City Sanitation, this community outreach team. Is y'all's training mainly in like customer service, or what exactly does that mean, community outreach team? Are y'all, what exactly is your function?
Community outreach and engagement, we're typically assigned to sewer projects, large and small, could be emergency sewer projects. We provide information to the community about sewer projects that are either upcoming in design or maybe an emergency case in which they have to get construction started very quickly. Could be small scale, could be large scale, but we help assist project teams, sewer project teams to be able to disseminate that information to the appropriate stakeholders or impacted property owners.
So that's the directive you guys receive. Do y'all get any sort of directive as to how to manage complainants or how to address their concerns or maybe even minimize their concerns or?
Our general protocol is to be able to respond within 24 hours of any of those types of sewer projects, to respond to them in kind. We try to strive for within an hour, 2 hours, just typically because we're always there and we're closely related to these project teams. We can speak to our project engineers, speak to the project inspectors, and be able to get to whatever complaint comes through. So we typically, it's within 24 hours, but we try to strive within the same day, within the same hour. But sometimes there's some after hours that we have to attend to the next day.
Okay. Again, I'm still just struggling to try to connect all the dots, especially with the AQMD inspector, with his comments and observations. Has anyone from your team actually physically gone to the facility?
We've gone, but in certain cases, such as an event or some sort of thing, but we're there at the ELC, which is the Education Learning Center, but we're not, as far as being around in the plant very in depth, we're not typically.
Have you yourself personally experienced any of these odors?
Not that I'm aware of.
When you went to the facility, you didn't smell anything?
No, I've been sparingly there, so at least at the times I have not.
And what about any of your colleagues?
Not that I'm aware of.
And no one from your team is based out of this place or goes there on a regular
No.
frequency?
No.
Has anyone from your team actually gone into the community or visited with complainants, face to face, for example?
Not face to face, and we have not visited.
Any town halls or community meetings?
There is a Hyperion Citizens Forum that we do quarterly, in which we talk to community members and give them updates about the Hyperion, and that's where we have those face-to-face conversations. It could be different team members or myself that has been a part of those types of.
How do those meetings typically go?
We do get a lot of complaints from community members, ongoing complaints about Hyperion. We also provide information from Hyperion staff as well and help elicit that information and disseminate that as far as that and help the staff to present their information.
So when y'all go back, your supervisors, managers, directors, what is the feedback? What is the analysis after a meeting like that? How do you respond to those?
As far as us, we provide and relay that information to Hyperion staff, let them know this is what has been discussed, this is what the complaints are made. And that's pretty much the end of ours. We would give it to them for them to.
And who are those people at Hyperion?
It could be any members, it could be differing members, but one of the most recent ones when I was with there was Hee-Sung Kim was present at that meeting. Any type
So
of.
it's exactly like corporate management of Hyperion.
Could be.
Okay, those are all my questions right now.
Earlier, you said you take a sampling of the complaints that come in. Did I hear that correctly?
I did a spot check or just a review of some of the complaints in our log.
Okay, and the spot check
Oh,
that you,
sorry. Yeah, continue.
okay, and the spot check that you do, is it a particular type of complaint or is it just random? Pick a random number from all of the complaints?
What I reviewed was in 2024, at least most recently after the last hearing. And I reviewed emails, those types of complaints that it required an email response. So that one I could corroborate on. I have another team member that does some mailings and she is not in the office right now. So I was unable to confirm at least those types of items.
I just want to provide clarification that Mr. Melendez is talking about what he reviewed in preparation of the hearing, and this is not something he does on as is part of his regular job duties.
That's correct.
Well, who does it as a part of their regular job duties?
That I would not be aware of. At least we just send in our reports after that. And
All right, thank you.
All right, any redirect or further questions to this witness? If not, we thank you, sir, very much for your time and testimony.
Could respondent redirect?
Oh, sure.
Hello, Mr. Melendez. Just to clarify, the testimony you provided about a spot check that was in preparation of the hearing today.
That's correct.
So the tracking log, which is weekly provided to AQMD, and we'll have another witness to describe what email that communication is made, that would reflect all of the reports that are going out. And your spot check was just an additional review for today. Is that right?
That's correct.
So a spot check isn't necessarily part of the regular process. The regular process is to actually respond.
That's correct. Thank you. Sorry for that misunderstanding.
I just had one last comment. You referred to these documents. Is there any reason why you wouldn't have submitted them for as exhibits?
It contains private information, would need redaction. It is provided to staff, and we'll have other testimony today as to the what feedback or lack of feedback from AQMD we've had as to those documents.
Just as a hearing board member, I felt uncomfortable that y'all were referring to documents that only y'all are privy to. So I just want y'all to understand that.
Thank you.
All right, thank you, sir. So Ms. Hoppenstein, how many other witnesses do you have?
We have one witness, although we have another witness, should you have further questions about outreach, town halls and the like, even though to the extent it came up in the questioning.
So an outreach maybe, and who's the one you definitely want to call?
Sharuze Sanae from operations.
Okay. Any idea of how long her testimony would take?
I can't imagine longer than 10 minutes, but it's up to the questions that this board has
Okay,
and the
so
district.
my thing is we'll break till 5 after. Is 45 minutes enough? And then I'm just trying to get a heads up to the next matter on the case that maybe 2:15 at the earliest, where 3 AM would be appropriate. just so you know, so at least you don't have to come back before then. So we'll break until 5 after 12.
Before we break, I just wanted
5 after 1,
to,
excuse me.
Mr. Melendez is actually ill, and if he could be excused for the day, we would really be appreciative of it.
No problem. Thank you,
Thank
sir.
you.
Appreciate you coming. All right, recess till 5 after 1.
Yes, thank you. Respondent would like to call Sharuze Sanae, please. And apologies, I believe it's Sanae.
Good afternoon, Ms. Sinai. Please identify yourselves by your name and your title, please.
Good afternoon, Sharuze Sanei, Senior Engineer with Process Engineering Division at Hyperion.
Spell your name for us, if you don't mind.
My name is
Spelling.
SHAHROUZEH and last name SANEIE.
S-A-N-E-I-A, Sinai. Thank you. All right, and you took the oath this morning? Were you sworn in and took the oath this morning?
Yes.
Thank you. Please proceed.
Thank you, Ms. Sanae. Before we begin, I would like to ask you some questions just about the Hyperion facility, because I know we do have a couple members here who haven't been at all of the proceedings and also for members of the public. The Hyperion wastewater reclamation plant, is that a facility that is that functions 24 hours a day, 7 days a week?
Yes.
And if you could please speak to the mic so that you could be audible, that would be helpful.
Sure.
And I'm sorry, is it a 24-hour, 7-day-a-week facility?
Yes.
Is there any ability to stop sewage from coming into Hyperion?
No.
And how many people does Hyperion service in the service area?
4 million people.
And that includes residents of Los Angeles?
Yes.
Does it also include different 20-something contract agencies?
That is correct.
Including El Segundo?
Yes.
And it serves an important government function?
Yes.
And what is it?
I'm sorry?
What is the government function that sanitation or Hyperion does for the community?
We are treating the sewage that is sent to the plant and complying with all the regulatory requirements, discharging it into the Santa Monica Bay. Also, we are required to comply with the other applicable regulation by AQMD, Air Resource Board, EPA, US EPA, Regional Board, and any government agencies.
And is the facility, we've heard a little bit about the facility being large. What is the acreage, if you know, of the facility?
144 acres.
And is that around the size of Disneyland, just for some of us who don't know?
That is correct.
So when we're hearing testimony about doors being open, we're talking about doors being open in certain buildings in a Disneyland size area, is that right?
That is correct.
Also, there were some questions that I'm going to try that the hearing board members had for earlier witnesses, and I'm going to see if maybe you can help us with those answers. There was a question about whether the Eagle monitor was approved by the district. Do you know if it was?
We are using Acrolog and Eagles, yes, both, yes.
And it was approved by the
Yes,
district?
yes.
And there was some discussion about the ex parte variance that came about in the February period. Do you remember that testimony?
Yes.
And the ex parte variance was introduced as an exhibit today, wasn't it?
Yes.
And that variance has expired?
That is correct.
And was there confirmation signed by you to the clerk that variance wasn't used, the primary battery tank D wasn't used during the variance period?
Yes, we sent an email, notified them that it hasn't been used and we don't need to do anything else.
So the conditions of that variance and the variance itself has expired?
That is correct.
And at the time in February, primary battery tank D had not completed the cover replacement, is that right?
That is correct.
And while it hadn't completed cover replacement, according to the order, it wasn't to be used, is that right?
That is correct.
But now the cover replacement is done?
Yes.
And that was verified in the testimony you heard from earlier today?
Yes.
And the status report, did you have an opportunity to review that, which was submitted to AQMD?
Yes.
And that attached as an exhibit the corroboration of completion of that activity?
Yes.
And now that the primary battery tank D has the covers replaced, it can be used by the plant, and so the plant has its full capacity.
Exactly. Yes, that is correct.
But at the time in February, it was not to be used Is that right?
Yes.
And so that's the difference today than we were 4 months
Yes.
ago. Or I guess almost 5 months ago. And with respect to the primary battery tank D cover replacement, was that the last capital project under the order to be delivered by Hyperion? All right. There has been some testimony, including from Mr. Melendez prior to the lunch break, about a tracking sheet that's submitted on a weekly basis to AQMD. Do you remember that testimony?
Yes.
Is that tracking sheet titled El Segundo Stakeholders Reporting Orders?
Yes.
And are you on the email sent to Inspector Haynes and also Kakishita from AQMD?
Yes.
And those emails happen on a weekly basis?
Yes.
But those are not, that report isn't sent to the clerk, for example.
I'm not sure.
But the email would reflect who receives it.
Yes.
And you see those weekly emails because you're copied on them?
Yes.
And this document, just generally speaking, the El Segundo Stakeholders Reporting Orders includes a column for the date and time that written responses are provided.
Yes.
And maybe I'm going to take a step back to describe the organizational structure at Hyperion or at sanitation. Is Hyperion its own department of the city, or is it part of a bureau or department at the city of LA?
It is part of a bureau under Public Work Department.
And what is the bureau called?
Bureau of Sanitation.
And the community outreach team that Josh Melendez is a part of, is that also part of the Bureau of Sanitation?
Yes.
And at Hyperion, there are a number of types of employees and staff there, right?
Yes.
Engineering,
Yes.
responsible for operations,
Engineering or supporting the operations. Yes.
and there's operations staff,
Yes.
and there's maintenance staff.
Yes.
And we had some testimony in earlier hearings about maintenance activities and declarations to that effect, right?
Yes.
But the community outreach team is part of sanitation, just like Hyperion staff is.
Exactly.
Okay, now I'm going to return to that El Segundo Stakeholders Reporting Odors form that's shared with AQMD on a weekly basis. Has AQMD staff ever asked you or staff under your supervision any follow-up on the contents of that form?
Not that I'm aware of.
Any questions about the written submissions that are reflected on that form?
I verbally, my staff has been told that we are in non-compliance, but we never got any details from it about it. So,
And did your staff ask for details?
yes.
So other than general statements, there was no follow-up on these forms?
No.
So not on specific dates that this form shows so-and-so received an email response, no follow-up to that level of detail?
That is correct.
There was some testimony about the Teledyne or the fence line monitoring system. And a question was asked, I believe, by one of the hearing board members as to who issues those notifications when there's an exceedance. Do you know who issues those
Yes,
notifications?
Montrose is doing that.
And is it like an auto email?
Yes.
But it's from Montrose, the vendor?
Yes.
And in addition to the fence line monitors, those, when I refer to the Teledyne system, do you know what I mean? Or
Yes.
And that's synonymous with the fence line system. Is that right?
Yes.
The location of the 3 units, was that decided in conjunction with AQMD?
Yes, it was during the first time that we received the order of abatement.
And in addition to those fence line monitors, and there's a central monitor, what are the 3 stations?
Central, South, and North.
In addition to that fence line system, are there also hydrogen sulfide monitors around the plant?
Yes, we have 8 AQMD portable monitoring system throughout the plant.
And the data is available whether of the Acrolog or the Teledyne monitors to AQMD?
Correct.
And are those weekly submissions?
Yes.
The tracking sheet is accompanied by weekly submissions of the Teledyne data, is that right?
That is correct.
Okay. Briefly, in addition to the website that has the Teledyne data, and who monitors or who manages that website?
Montrose?
Not Hyperion.
No,
So that website reflects an hour average, correct?
that is correct.
But in addition to that hour average data, is there 5-minute data taken by each unit?
Yes,
So the central Teledyne unit has 5-hour data readings?
yes,
The north Teledyne unit has 5-minute data readings?
yes,
And the south has 5-minute data readings?
yes,
And these data readings are provided on a weekly basis to AQMD?
yes.
So to the extent public, AQMD, anybody has questions about what's displayed on the website, would it be fair to say that there's information and data already available to the district on a 5-minute basis
Yes.
to confirm? And there was a question about the extra Teledyne unit on site in relationship to a June 27 invalid reporting. When there is a replacement of a Teledyne unit, does it take some time to do the replacement and calibration activities?
Yes,
And then to get stable readings of that new monitor or that new
Yes.
unit? From what you understand, would it have taken more time on responding to June 27 to replace that monitor than have Montrose address the readings as they had?
yes, it takes much longer than fixing the issues within few hours.
The primary tanks, are they vented to the air pollution control equipment?
Yes,
Have a few questions about 2 of the odor-related NOVs that we heard testimony about today. On July 9, are you familiar generally with that NOV?
yes,
And have you had an opportunity to look back at the available data, the fence line data for that date?
yes.
And did the readings show elevated levels of hydrogen sulfide?
Our monitoring system showed consistently low levels of H2S.
And hydrogen sulfide is the compound that the district also has said is related to smells
Yes,
from wastewater activities.
Yeah.
And did AQMD provide any information on location, time, and odor description from the verified complaints underlying that NOV?
I don't believe so.
And they don't usually.
No,
So any investigation you can do as to an NOV happens after the fact, as to
Yes.
cause?
yes,
And that's whether or not the cause is at Hyperion or outside Hyperion?
yes.
And that day for July 9, were there any odor complaints made to Hyperion? So not to AQMD, but to Hyperion itself?
I have to look at my notes.
So for July 9.
July 9th, we had two complaints.
And how about any data monitored by AQMD not related to Hyperion? There's a monitoring station at St. Anthony's Church, is that right?
Yes, yes,
Have you reviewed any data that might explain the timing of the odor complaints, at least the 2 that we do have information because
Yes.
it was made to Hyperion? What information do you have as to the time and potential cause related to those 2 complaints?
we looked at the air monitoring system located north of the nearby refinery, and we noticed VOCs, intermittent VOCs spikes. So we believe there are other sources in the area beside Hyperion that we need to look at. That day, nothing was going on. All of our equipment showed extremely low H2S. However, there was sharp intermittent spikes of VOC at the Chevron monitoring website.
Do you know if there was any at or near investigation of what may have been happening at the refinery that day?
I don't know.
Okay, turning to July 12, have you had an opportunity to familiarize yourself generally with that NOV?
Yes,
And what were the fence line readings?
extremely low, below 3,
But below the reportable amount?
definitely.
Below any
Way-
exceedance amount?
Yes.
And did AQMD provide any information on location, time, odor description of its verified complaints for that day?
No,
And that day, were there any odor complaints made to Hyperion?
0.
And throughout the day, hydrogen sulfide was was not at the reportable limit, right? It was well below?
Well below.
And the Teledyne units that are measuring the hydrogen sulfide, are they located relatively close to the community?
They are at the border of community and the plant.
So that presumably there's a reason AQMD chose the fence line monitoring at those locations. And have you reviewed any data potentially about outside sources on that day?
We looked at, again, the St. Anthony website and again, the same sharp intermittent spikes of VOC, we noticed that it was recording.
But do you know if that was investigated as a potential cause for that day of the odor complaints?
To our knowledge, that should be the only reason because there was nothing happening at the plant. And all of the monitoring system showed consistently low levels of H2S.
I think that's it for me for questions for this witness for now.
Thank you. Cross?
Thank you. Good afternoon. Did you hear the testimony of the inspectors saying that they reviewed the log or Hyperion's logs on 7/9 and 7/12, saying that there was cleaning of the battery tanks happening that day?
The cleaning is an ongoing process. There is nothing new. It has been happening for a long time. And we already implemented standard operating procedures. And based on the previous abatement orders when we do that, we try to minimize the opening and there is odor neutralizer in place and the foul air is vented to our air pollution control system. So we didn't do anything extraordinary on that day. This is something that has been going on for months and months. We're constantly repairing broken equipment.
Okay, and so does cleaning of the battery tanks or it requires you to open the tank covers? No? Okay, and so cleaning of the battery tanks, does that can potentially cause odors to the community?
We don't believe so. The monitoring system never showed any elevated level. Our actor log data has been provided to the AQMD staff, and we don't think that caused any nuisance to the community.
Okay, and why does it take 2 months to clean? Is that normal?
It's not about 2 months because that flood or storm event brought a lot of debris. When we had to bypass the headworks, a lot of rags and debris bypassed through the system and damaged a lot of the equipment. Now we have limited capacity, so we have to take one tank at a time out, and that cleaning process takes 3 or 4 days, if not longer. On top of that, the equipment that are damaged, there is a long lead. Sometimes it takes months, or if not longer, or 6 months or years to get the replacement part. That's why it can't happen overnight, and it takes a long time.
What equipment is damaged?
Like pumps or valves.
Mm-hmm. Is it because they're
and
old?
our electrical systems, a lot of things.
Is it because of the age of the equipment, or is it because of this big spill a big influx of flow that came in February?
Basically caused because of the influx of debris and rags that damaged the pump and broke some equipment. We are in the process of deragging and removing all the debris and rags that are all over the place in those tanks.
And what is the expected end date of this cleaning?
I think we are pretty much in a good shape right now. We have adequate capacity and we have to get to the best optimum performance within the, I guess, near future. Right now, that primary battery decovers are in place. We are in good shape. And we don't expect any, I mean, any situation that would cause additional flood or damage to the system.
Okay, earlier there was testimony about like the storm events, and when it happened in February, you were at limited capacity because you weren't supposed to be using tank D. So what was your capacity when you weren't using tank D? Do you know?
Without D, our capacity maximum is 500.
Okay, and with D?
With D, it can go up to 700.
Okay, and so with the potential storm event again, since all the tanks are covered now, you should be able to handle that capacity, correct?
Yes.
Okay, and do you have a storm, I think one of the board members asked about a storm plan in place.
We have a storm plan in place, and as long as it doesn't exceed like permitted capacity of 720, we should be able to handle it.
And what happens if it does?
If it is a one in a century event, then we have to bypass again and we have to use other options. But we are doing our best not to flood or damage the plant.
I couldn't understand what she said. How many per day was in the permit? 320, 720?
720 million gallons.
Okay, and has there been an event recently where you have exceeded 720?
Never.
Never, okay. You said that would be like once in a century or something
Yes.
event? Okay, what did you get to at this time in February?
We got up to 1 billion.
Billion with a B.
Okay.
950 million, close to 1 billion.
Okay, but doesn't that exceed 720?
Yes, it exceeded.
Oh, I know, that's what I was asking. Has it ever happened where you exceeded?
Beside that. I
Oh,
thought
okay.
you meant beside that.
Okay, so February was the
Yes,
event
very
that you
unusual.
exceeded, and
Yes,
other
event.
than the February event,
Yes.
you haven't exceeded
No.
720
No.
million
Yes,
gallons
yes.
before. Okay. Okay. Okay, so the truck loading facilities came up where the doors are not being closed. Are there personnel in there that can monitor this situation? Because it's
I'm sure there are supervisors that monitor the situation, but we have been dealing with emergencies last few months. And like Mr. Inspector Haynes mentioned, some of the doors are not functioning. So, and our trucks are long, so we have to keep the door open to use those trucks. But there is a plan in place to purchase the shorter truck. And also there is a capital improvement project in place to fix the building. We have emergency contract that would prioritize and address all these conditions.
okay, so the truck loading facility doors are broken.
So I think one of them is a stock. It's not really broken.
Okay, so it's so you're not able to comply with condition 41 at all then, because you can never close the doors.
Well, I believe they do, they use odor neutralizers and they do anything possible to minimize the odor, but at the same time, we never exceeded any H2S level. To use even checking the acrolog or the fence line, which is further away from the truck loading facility. None of them showed high levels of H2S.
Yes, I understand, but the condition 41 states that doors are to remain closed during loading and unloading. So that cannot be completed because the doors are broken.
One of the door are damaged, yes, I think.
Okay. Did you say?
Oh, after.
Okay, all right. And what about the other facilities that were mentioned, the headworks? building and I think the digester building, are those doors functioning?
They are functioning and yeah, everything is in perfect condition.
And do personnel work in there where
Yes.
they can monitor the doors?
Yes.
Okay.
I'm sure there are people that are there every day throughout
Can
the
they
plant.
be instructed to close the doors?
We have standard operating procedures and we can remind the supervisor and staff to observe those standard operating procedures. Yes.
Okay. Are you still operating, are you still conducting odor patrols?
Yes.
Okay. Do do the odor patrols ever contact complainants?
I haven't heard of that. No, I don't know. I haven't heard anything like that.
Is that a possibility that they can be the ones to contact complainants and when they're investigating odors?
I guess if they see something, they may, but I'm not aware of that situation ever happened.
Why isn't it that if odors are called in, since the odor patrols are already out there, why don't they just be the ones to investigate, go talk to the complainants and then they can investigate
That
it?
is our question too, because we never detect anything, but the community always complains about high levels of odors, despite the fact that nothing is shown on the fence line monitoring system and our portable unit doesn't show anything. Our odor patrol can't detect anything, so there is nothing we can do.
Well, the odor patrols can go to the site of the complainant's location
Yes.
and see if they also
They do
smell
that
the odors.
3 times a day. They survey the community 3 times a day, but we don't hear from them anything, any issues.
Okay. Okay, you've heard testimony from multiple members of the community that they are requesting callbacks, even though Hyperion records say they aren't requesting callbacks. So how can we fix this situation where they get their callbacks?
As far as I'm aware of the procedure, we are doing our best and we have always asked the complainers whether they want to call back and we check yes or no and we contact the community outreach team and they do the rest of the process. So we have complied with everything. I'm not sure why we are hearing complaints about the community about not getting the call back because we do.
Okay. Is there somebody from Hyperion? I know, okay. Is there somebody from headquarters that can ensure that the complainants are getting back their calls or getting their written summaries after their complaints?
Other than taking the picture or the copy of emails, I'm not sure exactly what else we need to do.
Well, earlier there was testimony that Hyperion sends over the record to the outreach group. But is there somebody from headquarters that can be the one to ensure that the complainant is getting called back and they're getting a written summary?
You mean high-level management?
No, somebody at headquarters. It's my understanding that they're off-site.
There is a possibility, I'm not sure. Yeah, we can add another layer of checking. We already have several layers.
I don't have any further questions at this time.
Just a few questions. Okay, sorry, just a few questions. There was there are several truck loading bays, correct?
Yes.
So when you were talking about a door being damaged or stuck, that's at one location?
Yes.
And it's in the biosolids truck loading area where it's stuck in the closed position, right?
Yes.
So it's closed, it's stuck, but it's closed.
Yes, yes.
And then a question about in the testimony that Inspector Haynes was giving about about complainants to Hyperion not getting written responses, did it sound to you from his testimony that he was referring to the weekly reports or some other log in the control room? If you know.
I don't know.
Okay. No further questions.
Anything else, Ms. Chavez?
No, thank you.
Board, Ms. Verdugo Peralta, any questions for this witness?
Yes. Sure. Madam, did you listen to all of Mr. Haynes' testimony this morning?
Yes.
Okay, so are you saying that he's either exaggerating or not telling the complete truth? How would you describe his testimony based on what you've just said now?
I guess he might misunderstand the situation. I'm not sure exactly how he does it, but our understanding is totally different.
And how long have you been involved with the Hyperion?
About 15 years.
So that's about the same amount of time that he's been inspecting, per what he said this morning, per his testimony.
Maybe.
Have you spoken to him in the past?
Recently, yes, last few years.
Last what?
Few years.
The last few years?
Yes.
Okay, so what he has been saying, have you been listening to him in reference to what you still need to do?
Yes.
So why isn't it getting done?
He hasn't told us specifically what we should be doing.
And what about all of the, whether it was a minute order or whether it was the last order for abatement? What about all of those items on there? They're not completed.
To my knowledge, we have complied with all the items of the abatement order.
Say that one more time.
We have complied with all the items.
You've complied with all of them.
Yes.
So the 1 hour notification to the AQMD has been completed every time.
1 hour,
You're supposed to be notifying the AQMD.
24 hours, I believe. One hour of what?
Okay, let's go on to something else. What about the notification of the doors? How long have you been talking to Mr. Haynes about closing the doors? Whether it's stuck in the closed position or not?
This is like a daily operation and the staff.
I understand that. I understand
Have
that.
been dealing with emergencies and I'm not sure why it's not happening 100% of the time. And we are human beings, but we are doing our best to comply and we have complied.
Well, not everybody agrees with that, but let me also ask, if he's been talking to you, and let's just take the one issue about the doors, that the doors still have not been closed. And I've seen it on the, whether it was the minute order or whether it was the order for abatement, that was the one main thing, especially according to Title V, that you have to be doing. And you're telling me that they're broken. Okay, so how long does it take to get fixed?
Yeah, broken but closed, but it doesn't release any future.
Have you contacted anybody to fix them?
Yes, of course.
Do you
We
have
a long list
documentation of that?
We have a long list of projects to repair all the
Okay.
damage.
Have you submitted that list to the AQMD?
Nobody asked us to submit a list.
Okay. Who is in charge of that facility? Where does the buck stop for that facility?
Are you asking about who the director is?
What I'm asking is who is the responsible party for all of these complaints that have been issued, for all of the directives from the AQMD to come into compliance? Who's the person who has ultimate responsibility to get them done?
I think this is a legal question that I can't answer.
What is your position there again?
Senior engineer,
Senior engineer. Who's above you?
plant manager,
The plant manager.
operating manager.
Okay,
Not-
and do you have weekly discussions about what you still need to come into compliance?
Yes, we have We communicate several times in a week. Yes.
Okay, so you discussed these things that you're out of compliance with and that you still need to address.
We don't believe you're out of compliance, but there are,
Well, our inspector seems to differ.
I'm not sure how to answer this.
Well, I think you really need to think about this because if you're telling us you're the party that we are speaking to now, you do have a person above you. You are in receipt of complaints from the public. The AQMD inspectors, 2 of them, have been out there for a number of years and there's still no real, how can I put it? I don't see a real big effort of trying to come into compliance with everything that's been identified. And there's been so many things that have been identified. And the people who are suffering for this, it's the public, as well as your own employees.
I'm one of them.
Okay. So what we're trying to do here is to get your facility to come into compliance so that there will not be health hazards that the public, they are experiencing, and I'm sure your own employees are experiencing based on the amount of emissions that are coming from that facility.
There are more than 50 items stated in the order of abatement. We have complied with all of them, and the door issue is something that we are still debating.
We're not debating it. It's on there. You're supposed to come into compliance. That's not a debate. That's an actual order on the orders of abatement, on the order of abatement within the conditions. That's an actual condition. And if you don't comply with that, you're out of compliance with Title V.
We are complying. The question is
Then the
whether-
doors would be closed. If you were in compliance, the doors would be able to be closed. And you're telling us that they are not because you haven't gotten to it for whatever reason. And I think it's too long of a time that you've had them not operational.
I'm not sure if any operation can be perfect 99% of the time. But
when was the last time that you contacted any company to come out and fix those doors?
As I said, we are dealing with emergencies. We have bar screens and pumps and reactors to.
Per Mr. Haynes, he said that these doors have not been able to be operational for quite a long time.
That I'm not aware of. I don't think that's true.
All right.
They have been operational.
I'm going to leave it. I'm going to leave that there because this is very telling. Thank you.
When it comes to community complaints, is there any follow-up with the community outreach team to find out or ascertain if they've spoken with the members of the community about their continuing complaints?
Yes, we get the weekly report from them and we submit them to the AQMD.
There was testimony earlier that that's not their job. So if they're testifying that's not their job, then what reports reflect that there's been community outreach other than a sampling since January 24th?
I can't follow the question.
All right. There was testimony that there's been a sampling since January 24th. And that it was not meant, he did not mean that they were contacting all of the complainants or addressing them. Let me finish. If I'm wrong, you can give me other information. But his testimony contradicts hers. There is a gap in what is happening here. There is no follow-up that I have heard. And I'm asking the witness, who follows up? Other than a report, who follows up to make sure that there is contact with members of the public about their complaints and concerns?
I believe you are asking there should be another layer of checking.
No, I'm asking who follows up?
The person that reviews the report and send it to AQMD. We get the report from the community outreach, we look at it and then we verify it and we send it back. I'm not sure.
Who responds to each and every complaint that is sent? Who gets back to them? We've had testimony that there hasn't been a response.
Member Macklin, we'll call another witness to help clarify this when Ms. Sine, she's not with the customer outreach team. And we'll clarify the testimony that may not have been communicated effectively prior, but we'll do that once. No, we'll wait until, do you want us to call another witness now or?
I'm sorry. Right now, Mr.
Okay.
Pierman is in charge of the hearing, and he's asked board members if we have questions. So we still have one more to go.
Okay.
And when we're done with this witness, of course, you can call another witness.
So we'll have another witness to clarify your question.
Multiple testimony that we've heard so far, because I am in agreement with my colleague, Peralta, that I have not heard who's doing what. And it seems as though no one is on first. And if someone is, no one's on second. And that this is a matter where there is not a sense of urgency to resolve after years of dealing with this issue. And if the order of abatement is not going to be followed, I at least want to hear what is the plan to follow it, other than it's on a list. Thank you.
Mr. O'Connell?
Thank you, Ms. Sine. Hearing your testimony, it appears like, Hyperion's doing a great job. There's no problems, is that that's what I'm hearing. Let me put it that way.
I said that we complied with all the order of abatement requirement. That's what I said.
Except 41. You're not complying with 41.
41 is.
Which is the doors, for the truck loadout. You're not, there's a condition
not in
saying.
compliance 100% of the time.
Okay,
Yes.
so you're not, okay. And you also mentioned that the surge, or, when you have heavy rain, so in 2021, that was exceeded the 750 million capacity.
No.
No?
No.
But that caused a lot of problems.
21 was a different story. It wasn't because of the big storm event.
Okay. What was the reason for
The reason was that we received a lot of debris which plugged up the bar screens, and it caused overflow and flooding of the plant. It had nothing to do with the high flows coming to the plant.
And the one that occurred this year was also, I heard, bar screens, rags, so
yes,
forth.
because we
plugging.
received a lot of rags. We had to bypass. Two things happened. We had a lot of flows that we couldn't handle. We had to bypass, which had a lot of debris and rags. Also, a lot of rags and debris caused the temporary plugging of the bar screen.
So what are you doing to address that? Because that's going to occur again.
We have several capital improvement projects to modify our bar screen and to increase the bypass capacity. We have a lot of projects in place and a lot of redundancy in place, but there is a long list that we have to prioritize.
Now, I think I've seen reports that you had previously upgraded those bar screens, correct?
Yes.
You spent a lot of capital,
yes.
But they're not working as effective as they should.
Yes.
So now you're saying they are going to be more improvements.
Maybe adding more bar screen, maybe we have more bypass capacity. We are doing a lot of other modification to make sure this thing never happens.
Is that put into some kind of a to-do list of a capital project approval that has gone through?
Yes.
Because yes, when you say yes, has gone and got approval to modify the bar screen, add more capacity, whatever it is.
We have a lot of capital improvement in project. I'm not sure how many of them are in conceptual report section, or whether they are approved or they are construction. But there is a long list of things to do that we are planning to do.
Okay.
And prioritizing.
And it appears you're putting a very low priority on the door that is broken, correct?
The door is not broken, but I mean, they are broken, but if they are stuck, they are stuck, but doesn't release any fugitive.
If they're stuck, how does the truck come in? Is there
They use other lanes.
The
other lanes, yes.
And so that lane is open?
Yes.
During the time you're going to load
yes.
and unload?
Yes.
Okay. So let me ask you another question, and this might have been addressed, but there was a condition to utilize portable roving monitors to continuously monitor around the facility And that was supposed to be submitted by, 2023. Do you know if that was submitted? Was anything identified from that project using the handheld units to go and see where those potential hotspots are in the plant?
We have installed 8 of them throughout the plant.
Inside or outside?
Inside.
Inside.
And also when there is an odor complaint, then is using one of them to make sure, to find the possible source. So we have those and you're using those.
Okay. The inspector clearly indicated the one the inspector gave you the notice of violation on July 7 or the 9th, July 7.
July 7th?
Let me see.
9th.
July 9th. I think there were 2 dates. One, the inspector gave another, July 9th. The inspector testified, he issued the notice of violation. And he did testify that there was egg odors and he smelled. That was his testimony. And that's why and also he heard from the public and he issued a notice of violation. And July 12th, and also there was another notice of violation. And then they don't issue a notice of violation unless there's cause for it. So, but you're saying, there's no cause for it.
I said that those days we didn't find any possible odor generation activity at the plant, and we looked at the refinery website, and we noticed short VOC spikes that could be the cause. We are not the only source in the community.
Okay, but he's at your facility when he's smelling that odor, isn't
Then
he?
how come our monitoring system didn't show? How come the acrolog
And
system
that's my
didn't
question.
show?
Why is there a discrepancy? The inspector is
I
smelling
can't
it.
answer that.
And you're saying, no,
We have the document. I can't answer that.
Is it possible then the monitors are not located at the right location? Or maybe there are other,
The
other
fence line
explanation?
monitoring was approved by AQMD. And those 8 portable ones are close to the highest possible source of the odors. And they are not a requirement. We did it on our own. So we are doing our best.
Okay. And the other one I have concern about, you said there are parts that are damaged and pumps.
Yes.
And you're talking about a long-term to replace those. Don't you have spares or don't you?
Yes, we do have a spares,
And,
but some parts may take longer. Sometimes the part hasn't delayed our progress, but we have limited human resources and budget and all that. But we have prioritized and put highest priority on the odor control projects.
And
that hasn't stopped us at all.
And so you're saying none of the pumps that are not working are contributing or maybe result in contribution to the odor?
At this point, no, they're all in perfect condition. Everything is working. But again, they're like, someone asked why we are repairing the primary battery D, and I mentioned that some equipment broke and we have to fix it. And it takes a while to fix it, and there are other priorities.
Right. I think I heard you on that. Okay, let me ask the other question I had that I can't remember now. So what is your highest priority?
Making sure that our head works in good condition, our primary tanks are in good condition, and our effluent pumping plant pumps are all in working condition in case if any flood happens. So, and also we have to maintain our digester gas utilization facility that it generates electricity using gas, and it has to do gas cleanup to provide gas and from the digesters to the cogen facility. We have a lot of very important projects that they need to be in working condition. Otherwise, we are going to be in more violation.
Right. And I remember the question. I think one of the inspector's testimony was he attributed the odors coming from the cleaning of the tank. Did you hear that?
Yes, I heard that.
And you're saying he's wrong? That's not the source?
It could be the main source, but I said that we have a standard operating procedure for tank cleaning. We make sure that the opening is minimized and there is a fan and odor neutralizer and the foul air is vented to the air pollution control scrubbers. We are doing everything based on the requirement of order of abatement to minimize and reduce the odor generation.
And yet you're causing an odor.
If you are standing next to the tank, maybe, but if you are on the hill, which shows below 5 ppb, no.
Below where, I'm sorry?
5 part per
I
billion,
know, which part of the facility?
the borderline between community and the plant.
Right.
Yes, but they are not standing next to the plant, next to the tank.
So you're saying it's quite high near the tank?
Could be higher than the fence line.
Fence
I'm
line.
not saying
And
higher.
It is getting dissipated, to the community, right? It's going to go somewhere. Let's say it is 50 ppm at the tank, and you don't register as a fence line, but that 50 ppm concentration is getting dissipated to the community, correct?
I'm saying that we are using odor neutralizer, we are using flexible hose to vent the foul air to the air pollution facility. And if there is a fugitive for a few seconds, I'm not sure exactly what happened considering the temperature, the wind direction, and other factors.
Is there anything more that you have identified that you can do?
I think we have exhausted everything that we have to do. That was the requirement of last order. That what is our procedure to minimize the odor generation during the cleaning activities, and that was approved by AQMD. And if I correctly remember, there was a site visit by the AQMD staff, and they observed our operation, and they approved it.
Right, but again, I don't have back, the inspector clearly identified the cleaning as a source.
It could be a source of odor, but it's not to the point that would cause nuisance at the community. If you're standing by the tank, you may smell it, I'm not sure. But we are talking about temperature, wind, and other factors by the time it gets to the community. And if those fence line data doesn't mean anything, I don't know why we installed them, because they all consistently show low level, and it appears that it's not meaningful data for anyone.
So when you heard a member of the public testify, she had to leave the house. It was so bad on one of those dates where the initial reading the Montrose had was showing about 31 ppb. You were saying that was it didn't happen?
The day that there was an issue with this system, of course, yes, Montrose officially told us there is an issue with the system and this data is not valid. And they recently sent me an email that these, according to the EPA, the monitoring system or this kind of equipment are supposed to be valid 80% of the time. Their system has been valid 95% of the time. There were very few occasions that we had issues that we had to fix. But during that time, the actual data is still captured and uploaded later on. And we have other backup. Just one instance of I think only 1 minute exceedance, which wasn't valid, shouldn't supersede the rest of the data and other information.
So the testimony was it was so bad she had to leave, right? And had to leave the house.
I'm sorry?
I think the testimony I heard was it was very bad that she had to leave the house.
I can't speak for her.
Okay. All right. No, I have no further questions. Thank you.
Couple of questions, if you can answer this. So apparently there were 3 Teledyne monitoring systems, and then the order we mentioned at section 4, I believe, they were called basically 1, 2, and 3, site 1, 2, and 3. But in the monthly reports done, for example, the June one by your company, it mentions in December 2023, ongoing design for Teledyne relocation pending decision from SC AQMD. if it is required to move the south monitoring station. So my first question is, of 1, 2, and 3, what is considered the south monitoring station?
I don't remember. South,
That's the terminology in your monthly report dealing with condition 4.
I believe 3 is considered south.
That makes sense. And now, are you, meaning HTP, seeking to relocate that, or are you satisfied with its location?
We believe the existing location is the optimum location. We also discussed it with AQMD. They verbally agreed. We submitted a request and we haven't heard back if they agree to keep it or move it. But we have plan in place. If we are required to move, we move it. But I believe it's going to be in the middle of the road and existing location is at the optimum location.
So this has been on the report for 6 months. Any explanation from AQMD to you why they're not making a decision one way or the
We
other?
contacted AQMD a few times. We haven't heard.
Okay, thank you. Now, among the conditions initially, I think in 2 involve training and retraining. And it said that you shall hire a consultant to provide refresher training semi-annually for all relevant employees. Respondents shall maintain records documenting both initial and refresher training. So to your knowledge, has the refresher training been going on every 6 months?
Yes.
And do you send those records documenting that to AQMD, or you just keep them internally?
I'm not sure if we have to send those records, and if we have to, I guess we have sent it, but I'm not sure if it is a requirement.
Okay. Now, the status report that was filed, and it's been Exhibit 9 today, that I think you referenced, did you have a hand in drafting that report?
The status
This
report, I
Wednesday
reviewed
status
it.
report? You reviewed it and agreed with it, apparently?
Yes.
Well, I mean, not a question, but I guess a comment. I was kind of befuddled when I got this report, Ms. Hoppenstat, because it said you had completed or fulfilling the last outstanding condition, which I thought meant, smelled like Febreze at the site now. But you had 2 NOVs in July, 116 complaints, monthly report steps admittedly not done, like item 41 to doors, and you've agreed to a stipulation that said there are still deliverables due. And I know your lawyer mentioned that it was not, she tried to couch in the sense that you meant to say capital projects were complete, although the witness now says they're still ongoing. But you are still, madam, stating that you completed all conditions. That's just a lie. It's a lie. So if you want to keep shredding your credibility, keep saying that, I would suggest you come up with a new way to phrase what you've done so far. Any other questions from the board?
No, thank you.
Thank you. You want to call the other witness? You got a question?
May I
Sure.
just redirect? Mr. Saini, do you recall a submission to this board prior to the last status conference that provided confirmation of the training and retraining?
Yes.
So while it may not be every training or retraining, there is some exhibit in the record before the hearing board and available to the public should they want to look at those training records.
Yes.
And to the extent that there has been several comments and questions about the consistency of keeping the truck loading facility doors closed during loading and unloading activities, which is what the condition specifies, is it your intention to take back to the facility to ensure that SOPs are being followed and that even further compliance is achieved?
Yeah.
Okay, no further questions for this witness.
Any recourse to further board questions? Can we release the witness? All right, thank you very much, ma'am.
Respondent would like to call Tanya Shelton.
Good afternoon, Ms. Shelton. I believe I saw you stand and take the oath today. Could you identify yourself, your title, and spell your name, please, for the record?
Yes, Tanya Shelton. I'm Public Information Director for LA Sanitation and Environment. I'm sorry, Shelton, Tanya, Tonya.
And did you take the oath today, Ms. Shelton?
Yes, I did. Thank you.
Ms. Shelton, you've been in the room for the course of the testimony.
Yes.
And did you hear questions from the hearing board today about what corroboration and confirmation is happening at sanitation with respect to the complaints made to Hyperion? Do you recall some of those questions?
Yes, I did.
Could you clarify what is your position with respect to the community outreach team?
So I lead the community outreach team. Right now, there are a number of those representatives who are assigned to the Hyperion odor compliance team. And I receive those initial complaints and then I distribute them to one of those team members. Joshua Melendez was here earlier. Allison Arnold is another person who is assigned.
And those team members, we've heard some testimony about a report, El Segundo stakeholder report. I think I'm butchering the title a bit. But El Segundo stakeholders reporting odors report. Are you familiar with that report or log?
Yes, I am.
And is that something that staff under your supervision inputs?
Yes, every time I send a complaint and I assigned it to them, they enter their steps in that spreadsheet, and then on a weekly basis, we provide it to Hyperion. And those steps include following up in terms of a phone call, email, or even mailing the report, a hard copy via U.S. Postal Service.
And there were questions about accountability that were presented today. With respect to that report, what level of accountability or what steps are being taken by you or your team to make sure that the complaints are being responded to and that's being tracked?
The highest level, I personally receive those complaints. I also receive a phone call from the Hyperion control room saying that they're going to be emailing me the complaint as soon as I receive it, within minutes of receiving these complaints, and they're 24/7. I forward the complaint to the assigned team member, and that team member within 24 hours calls back and follows up and does the appropriate mailing or emailing. And we're even now texting the report to some people who have requested that.
And you heard the testimony from Mr. Melendez about a spot check.
Yeah.
Did you understand that a spot check is all that happens on a regular basis, or was that something for today?
No, so Josh was, Mr. Melendez was taking a look at our efficiency rate, if you will, because we take this very seriously. So we wanted to see over a period of, I guess, 6 months now, what we've done. And we have a 98% accuracy rate. And for that small 2%, we're not sure what happened, but we return calls, we send emails, and we make sure that people get the reports as requested because we know how important and what a priority this is.
And does your staff maintain the record keeping of the emails that are sent out?
Yes, they do.
Of the texts that are sent out?
Yes, they do.
Has there been effort even since the last hearing to make sure that anything that's put in the mail, that there's corroboration for that?
Yes, and because it would be cost prohibitive to send these reports, some special
certified mail.
Certified mail, thank you. We are now taking a photo of the letter before mailing it, just to say, we were at the post office, we sent this off, and beyond that, we, obviously have no control, but we are taking photos to make sure that for those mailed reports, we have documentation of that. And we don't have that many who are requesting mailed reports, but quite a few request email and again, text reports.
Have you ever received any communication directly or indirectly from AQMD that they are looking for that documentary backup?
No, no.
But if they did, you had it?
Yes, yes. We also have our call records indicating who we've called back, should that be necessary.
When the written report is sent in whatever form it's sent and reflected on that log, is there any follow-up with the control room? Does the shifty know what happened, or how is that, which direction is information moving?
So that shifty or the control room, again, they will call me and email me the report. I then distribute the report to a team member. We close it out by finalizing our steps in terms of sending out the report, making a phone call, mailing off the report, and then sending a weekly document of those efforts to Hyperion to submit, I believe, to AQMD. So I think that is the way that the loop is closed in terms of, how it begins with the shifty.
Because your group is completing the process.
That's right, that's right.
And maintaining the records for it.
That's correct.
Records that haven't been requested by AQMD, to your knowledge?
To my knowledge, no.
There were some earlier questions about our outreach outside of the abatement order. What communications are made to the community, just generally from Hyperion in terms of you're a neighbor to other stakeholders?
Absolutely. We have, I know that Mr. Melendez talked a little bit about the citizens forum meetings that we hold. Those meetings date back more than 10, 15 years. We've been a partner in the El Segundo community for many years, and we know that partnership is a bit fractured, and we're doing everything possible to regain the confidence of the community. So we are sending out notices as frequently as possible to notify those people in the community about potential odors. We send out regular updates via our MailChimp system that's point to maintenance, ongoing maintenance, and maintenance projects that may in fact cause odors. Following the 2021 incident, weeks following that incident, we put together an interagency task force that has amongst its members city officials with El Segundo, the city of Los Angeles, county representatives, county health, as well as county fire, so that we all can communicate more effectively and transparently.
And there were some questions earlier from this board about town halls. To the extent there are further questions, are you able to respond to those?
Yes, we have called special meetings regarding the issue in 2021. And again, we continue to hold regular meetings with the community. Beyond that, again, we have our ongoing materials that we send out, our e-blast. We host various tours of the facility to show our progress. In fact, there is one coming up, I believe, next week with City of El Segundo officials. So we continue to reach out to the community and build that partnership.
And is communication with the community something that you're working on now?
Yes, absolutely. We are looking to even add to our team to make sure that we have enough folks dedicated. And while we are not stationed specifically at Hyperion, that doesn't matter. We know that it's the top priority. I myself am at Hyperion quite frequently. I'm not stationed there, but we know that would be something that could be valuable. So we're even looking at that.
No further questions from me.
The redirect for her, so to speak, recross, I should say. First cross, yeah.
Just a question. Thank you. How long has your team been handling getting written summaries back to the complainant?
I think under 2 years. I can't be sure, but about 2 years now.
And has the process changed at all in the last 2 years?
No, the process hasn't changed. We have refined it, we've improved it, but it hasn't changed in that we receive the complaint, we detail with the control room what has occurred, what follow-up has taken place, and then we convey that to the complainant. So that hasn't changed.
Heard multiple complainants talk, and I don't know if you see the comment letters that they're getting, but they have tracked when they have not received written summaries. So how do you explain their complaints, or are you able to go back and look, and how do you fix that?
Yeah, that points to that 98% efficiency rate I spoke to. We call people back, we email, we mail. So I'm not sure where the breakdown is. I would say that we have email documentation to show when we've sent out emails. We have text records. So again, I can't speak to why that might be happening on that end.
And all your written summary responses, are they issued within 96 hours?
Yes, yes, that we realize that is a requirement. It may be in the last few months that hasn't happened for whatever reason, an emergency, once or twice. But 9 out of 10 times, or I want to say 10 times out of 10 times, we do meet that 96-hour.
Okay, so in the last few months, there have been times where it comes after the whole 6 hours.
Maybe 1 or 2 times.
What were those emergencies?
Those would be staff-related emergencies. I don't have that information readily available.
At these citizen forums, have you heard public members talk about receiving the written summaries, or complain about not receiving the written summaries, or callbacks?
Not really. We talk a lot about the plant maintenance projects, ongoing concerns, odors, but I haven't really heard that being brought up at our citizens forum meetings.
How would okay, let me set the scenario. It appears that headquarters received the call and then they send the complaint to you. Some of the complainants are saying they're not receiving a callback, and it could be checked that they don't want a callback.
Right.
So how can the complainant ensure if they want a callback that they get a callback? That they don't have any connection to you directly?
Right. It's my understanding that the control room, the shifty, as we call it, will ask, do you want to call back? And they check this box, yes or no. And that is relayed to us. And if there's a callback requested, we absolutely call that person.
Board members? All right. Thank you, Ms. Shelton, for your testimony.
Thank you.
We do have a hand raised online.
Can you let that person in if they still want to speak, Dee? He or she can hear me. There a witness out there that we missed? A commenter, I should say? Or perhaps just mistakenly have their hand raised. Going
Okay.
once?
He has to allow them to see. Okay. Aaron?
Hi, I'm here.
Okay. Did you want to make a comment?
Yes, just a public comment.
Okay, please just identify yourself, and then once you've done that, Aaron, you'll have 3 minutes.
Thank you. My name is Erin Falati. I'm a resident here in El Segundo. I apologize for my voice. I'm very sick, so I wasn't planning on speaking today, but I felt compelled to after hearing some of what we've heard today. So thanks for taking the time to listen. I did provide also a written email to the board excuse me. Just want to hit on a couple points really quick, where the engineer has been talking about the doors not being closed. I would just like the board to know that that's an excuse that has been given to me, at least when I've called Hyperion, dating back to after the 2021 incident. So it's clearly doesn't seem to be a priority for them to close a door, even though it seems like that would be required of any facility. Excuse me. Additionally, I just wanted to hit on the point that the engineer was speaking of the fence line monitoring showing very, very levels of H2S consistently. And if it helps the board, I've submitted documents as well, but this seems to be only since they did maintenance recently. I think it was about a month or so ago. Prior to that, it would show consistently high readings, or it would be intermittent. Now we are stuck in a situation where I am directly east of the central monitor and pretty close to the plant, and I'm smelling absolute rotten eggs and sewage. I know where it's coming from, and yet their fence line monitors are in fact showing consistently low levels of H2S. We've talked to AQMD about this, but I hope maybe it's something that AQMD or Montrose or someone could look into further, because I do not feel that we are getting accurate readings since the maintenance was completed. And finally, I just wanted to go along with what, excuse me, the other resident, Tamara, said this morning about having to leave town. My family and I leave town almost at any chance we get, and I can't tell you how heartbreaking that is and stressful and time consuming it is. We live in El Segundo because we love our community and we want to be here and support our fellow residents, our businesses here. But it smells so bad, or we have such health effects, that we have to take our young children out of town whenever we can. It's not a situation that has changed since 2021. It has not gotten better, so to speak. And the residents, I think, are kind of throwing our hands up in the air a bit that it doesn't seem to be changing. So I'm very thankful for you having these hearing boards and allowing us to speak. And I thank you for your time to hear my comments today.
Thank you, Ms. Filati. Any other witnesses to respond?
No other witnesses.
Well, then we're ready for closing. Mr. President, first, one question I asked you is whether or not, and this is Mr. Haynes, that you have any additional conditions, or you want there were conditions percolating upstairs that will be presented to us later, or what's the condition or that concern you might address that?
Thank you. Chair, members of the board, or Vice Chair, excuse me. Thank you for your attention today, and to the members of the public providing testimony. I think we came into the hearing today not intending to add additional conditions at this time, and we're really just seeking an extension today of the order for abatement, given that AQMD has found still violations of OA conditions and the recent nuisance NOVs. But we've heard a lot of testimony today that was concerning, and so I think the district will need time to evaluate and see if whether additional conditions are needed maybe at the next hearing or before that if possible. But today, with the recent NOVs, we'd really like to extend the jurisdiction through January 3rd, 2025, which is stipulated at this time, and have a further hearing November 20th or earlier if the board sees necessary. We do think that with the battery tanks now being covered and the continued enforcement of the OA conditions, we do expect progress and with the odors and hopefully compliance with all the OA conditions. Thank you.
So just speaking for myself, that possibility of continuing it while you develop conditions, has some value. You're familiar with the conditions. It's very long, and also you could try and get some agreement from the other party, which helps, but I wasn't thinking November, I'm thinking 3 or 4 weeks. Is that doable from your standpoint, that you could create potential conditions based upon your concerns and what you might have from the board, might hear from the board in their deliberations?
We have not just discussed any additional conditions internally, frankly. So that is something that we would have to evaluate with staff. 3 to 4 weeks, maybe a month out would be sufficient time.
Hyperion?
Thank you for your time today and for hearing the testimony. And we hope at the next hearing, whenever that may be, that we hear a fuller narrative about full compliance as what the facility is striving to achieve.
Do you want to take a break and then deliberate? How you doing, board members? It's been an hour and a half.
Finish it and then take a
Finish
break.
up?
Yeah.
I'm sorry, what'd you say, Cynthia?
Finish.
Okay, great. So I think that we have 2 options. It's kind of impose our own conditions we want, or give a short time frame, not November, but 3 or 4 a month, to have them presented by the district first, along with extending the time of the order. So kind of what's your pleasure here in the deliberation? I'd like to address that. Ms. Verdugo-Peralta, any thoughts on that, first of all?
I would like them ASAP, and I really would emphasize that we take Mr. Haynes and Mr. Lee's comments to heart, because obviously the job that was written and they are saying is completed, and they've done this and they've done that, they haven't done it. And the people who are suffering the most are the residents around it. We have one employee saying that there's no odor, yet we have all of these complaints. How can that be? So I would love to see a report sooner rather than later, and I would love to see more conditions and make sure that the ones that are on the books are being complied with, and if they are not, that there be some type of, I don't know, penalty. There has to be something that's got to be done, because we keep on kicking this can down the road year after year after year. And I've been listening to this from the get-go, and it's only getting worse. It's not getting better. So what do we need to do to make this get better? I'd love to see any suggestions from the staff for that.
Thank you. And yes, there is an air of repetition in what we're hearing.
Yeah, I think hearing back sooner rather than later, whether that's 4 weeks, 6 weeks, within 2 months, maybe, depending on how that works with the district and being able to create additional conditions. I'm not really sure what is going to be the, what is really going to move Hyperion to action to address this issue. It sounds like nothing's really done that, and it just sounds like we've got a lot of conditions that we're not really complying with. I'm still baffled by just the public has clearly their complaints, the district inspectors have their reality, but I'm seeing a very different reality every time we hear from anyone from Hyperion. And so I've got to figure out why is that? We're going to reconcile some of those things. Guess lastly, what can be done right now, I think is a very important question. And I don't think there's a obvious answer, but I don't believe we're ready for the next event. And I don't think it's once in a century. It's going to be possibly this fall. It's going to be possibly this winter. And I just don't feel like we're really addressing the issue that was right in front of us.
Ms. Conagher-Macklin?
Yes. I appreciate all of the testimony that's been given today, but I too hear a disconnect. And I see the public suffering. It's the community that's suffering while everybody seeks to get their act together or point fingers at everybody else about what's been done and not been done. This order of abatement is a serious matter, and I don't see that it's being taken seriously, really. It's on a list of things to do, and when it gets done, and the public will just have to wait. Well, how long is long enough? And I think as a board member, we have a responsibility to protect the interest of the public while ensuring we are fair with the agency. But the agency likewise has to take this matter to heart and not continue to give us testimony that I find frankly a bit concerning. It's contradictory. I said earlier, and I'll say it again, I'm not sure who's on first with what. I hear the community saying one thing, I hear the inspectors saying another thing, then I hear Hyperion saying something totally different. That would lead one to believe there are no odors. Every complaint is answered up to 98% of the time. And I'm just not convinced that's the case. So there have to be some ramifications for non-compliance. So while I'd like to afford until November to kind of figure out what the other conditions should be, I think that's too long to ask anyone to wait. And I think we've heard enough testimony today that it can be sooner rather than later. So I would ask for 3 weeks, if not 2, 3 weeks, so that we can make a decision and move forward on this matter with the basis of knowledge and information. And maybe then Hyperion will be able to provide some of the documents to back up what they've said. I haven't seen one document to substantiate that there's a 98% compliance rate with the community. And I'd like to see those things to know exactly where we are. So I'm good. Thank you. Thank you.
Yes, I'm heartened to hear from the district that they're willing to revisit and add, modify condition. And I think, a month is reasonable, but 3, whatever the board, so I think a month is reasonable to get to with the other party to come and come up with the condition that they can stipulate on. But a few things I want to add. Clearly, they're in violation of condition 41. And there has to be some repercussion for that. And I would suggest when you're looking at it that they do, it seems like that they should repair it as soon as possible. If they can't, or whatever reason, that we put a requirement that they do handheld monitoring during the time they're loading, and get those readings and submit that to the district during that period, so that we can tell. And then the second thing, and I know the burden is on the respondent, but I think we heard potentially that the district hasn't given final approval on the location of the monitor. I think that's something that should be emphasized to the agency to, maybe clearly there are indications that the community is experiencing, but the monitor we heard from Ms. Sinea is showing, no compliance. So maybe there's a disconnect. Maybe there should be relocation. I don't know. I think we need the district and monitoring expertise staff to weigh in on that. And, and at the next hearing, we get information on that. The other thing Ms. Sinea said, there are some capital improvement projects. I think we have heard that in the past. We have seen that a report was submitted on the proposed capital improvement project, and it looks like this 1 in a 100-year event is going to occur more frequently. And there was 1 billion gallons. The rain, it was not that severe compared to 2021 when I felt, and we saw the horrendous pictures with the flooding at the facility. We didn't see that this time. So this is something it's going to occur again. So we need to see what the agency has in plan to address that going down the road. What capital projects improvement they're doing, even if it's not approved yet, at least what they're thinking of doing. And I think the last point is Mr. Haynes said they had some suggestion which they submitted to the former compliance manager, and we need to hear, at least have the agents, the district review that and see if permitting has any other things that they want to add, because I don't want to see us extending and extending. I personally, I like to finish it next, the next status hearing or the last date and not extend it further. But to do that, I would need the assurance that some of these things, capital improvement projects, are going to take place. Some of the conditions that the inspectors or the engineers are going to put after the orders resolved, because then they can issue the permit, what they are. So there's some assurance that we can then, say, okay, our jurisdiction on this order ends. I feel comfortable doing that, at the next status, not the next status, but the one in November, which is what is stated, what do you call, what I think it's calendared for in the finding and decision document. So a month, I'm okay with a month, so.
All right. So just adding my thoughts in terms of what we might ask the district and Hyperion to come back with. You've heard us express our concerns, including the door issue, the outreach and whether the complaints are being called back, et cetera. I think that, as Inspector Haynes mentioned, maybe some of the conditions need updating to currency to see if they work and especially not being followed. So for example, in the original prior orders, condition 1 dealt with a complaint response program. Conditions 15 and 16 dealt with acting upon a implementation plan from a consultant's report, and 42 and 43 dealt with an odor mitigation work practice procedures dealing with truck entry, et cetera. So I think, consider whether those should be reevaluated and updated or improved. And then I think this question that again has been asked recently is especially from the district, do you feel comfortable that they can truly handle a catastrophic up to 720 as they claim that their capital projects will allow them to do so? Or if we know and the community knows if something happens where it's more than 300 million per day, they're going to have a problem again. They'd like to know that, and we'd like to know that. Madam Clerk, I'm looking at the last week in August, and it looks like the 28th, we have nothing on calendar. Can you check that? That's a Wednesday, it's the 28th. We have something on the 27th and 29th. We could do it the same day, but I still would give it its own day.
And our community meeting is on the 17th, I think.
At Chiquita, yeah.
Yeah.
Mr. Chair, may I make a phone call to confirm when the first day of school is for my children? Because that might conflict with the dates that you're contemplating. Okay,
We'll take a break question.
thank you.
On break for a minute or two, Dean. Anyone, she can't do the 28th, so anyone looks like it's the least likely to be a long one on the 27th or 29th? Okay. 29 is just borrowing?
29, actually, for possible. SoCal Gas.
Environment is still on that count?
Environment is still on there,
so. Want to do that? Because I think we're not expecting a whole lot of talking, just give us the conditions, and let's write something up, right?
Yeah.
Or even look at
29. What were we saying?
We do have that order for abatement, potentially SoCal Gas on that day as well.
The 29th is the first day of school and the 28th is the orientation day. So those are conflicts for me.
How about the September, first week in September?
Labor Day the 2nd, okay, so, we have the 2nd, the 3rd, Tuesday, September 3rd.
We have nothing on the 3rd or the 5th.
Okay, Dee, we're back on the record. First board members, would September 3rd, which is the day after Labor Day, be good? Or would you rather the 5th, just in case you're late getting back from vacation or something?
5th is good.
Okay.
Now, I will add that they are looking at possibly the 3rd and the 5th for another OA for valley plating.
They'll be second, because we'll be first. Does the 5th look good for the board members?
Yeah.
All right. And Ms. Hoppenstein, you think that's all right for you?
Yes, thank you for that.
Ms. Chavez? Okay. Would the parties then agree, since we have to have a motion, I'm anticipating that what we do is we'd find good cause to extend the compliance deadline to January 3rd, 2025, as you suggested, and have a new status hearing to consider modification on September 5th. Is that stipulated then by both parties?
Stipulated for respondent.
Okay, good. All right. So first, I'll make the motion that we find good cause based on the record before us and the testimony today and the exhibits and the stipulation of the parties that we modify the order by extending it to January 3rd, 2025, and have a hearing on September 5th, 2024 as a status conference to consider any modification of the order for abatement. Do I have a second?
I'll second.
Okay. Any further discussion or deliberation? All right. Ms. Verdugo Peralta,
Aye.
Dr. Abraham,
Aye.
Adrian,
Aye.
Mohan,
Aye.
and I vote aye. All right. Thank you very much. Hopefully both sides have heard our concerns, and we trust when we come back on the 25th, a lot of these will be rectified. Thank you. Let's Go back on. So I'll assume the recording is still in operation. Good afternoon. We're here to hear the second matter on today's calendar. South Coast AQMD versus 3M Healthcare US OPCO LLC, case number 6256-2. And as before, we're going to first see who's representing the parties, see what exhibits they may want to introduce, swear in witnesses, allow any public comments or public testimony before we begin the cases in chief. So to begin, who do we have here for the district?
Good afternoon, Josephine Lee on behalf of the executive officer.
And for 3M?
Good afternoon, Vice Chair and members of the board. My name is Andrew Brady of the DLA Piper Firm, counsel for 3M. And I'll introduce the two individuals with us. We have Bob Wilcox. He is the engineering and plant supervisor at the facility at issue here. And Bruce Armbruster is here, who is our expert consultant. They are available to answer questions. So if the board wishes to swear them in, if there are questions for them, they can be sworn in to give testimony and answer any questions that the board may have.
All right. Now, before we get to the exhibits, I noticed there were, among other things, some back and forth with board members' comments, and we had your stipulated proposed findings and decision. In light of that interplay, will you plan to make any additions or changes to the proposal that you've also stipulated to, or you can present it to us as provided already?
The district does not propose to make any changes. In fact, the petitioner has already moved forward in implementing some of the conditions, and so they are ahead of schedule. But I think it's fine to leave those conditions as is, just so that they are enforceable and still in the order.
All right. Well, then let's mark the exhibits, and we'll just mark everything that came in the stipulation package for now. So we'll start with the stipulation, even though we've not put a consent, as item 1. Declaration of Daniel Hernandez, item 2. Declaration of Bob Wilcox, item 3. Proposed findings and decision for an order, item 4.
Vice Chair, we actually have an additional declaration from the district.
I have Wilcox, I have Stewart, yes, okay, I missed that one. We'll make Stewart's number 5. First, let me ask each party, even though we pull a consent, do you want those exhibits, including the declarations, et cetera, incorporated into the record?
Yes, please.
Respondent has no objection to incorporating the exhibits into the record.
We'll do so. That will short circuit some of the time needed for testimony. And then we have some communications between Mr. Mulligapan and the clerk's office to the parties, which the clerk has not provided me about to make copies. So she'll be making copies of those in a minute, and they'll be hearing board exhibits. So while we're waiting for that, first, could anyone who plans to be a witness, either giving testimony as a member of the public, subject to cross-examination, et cetera, or a witness for the parties, stand and raise your right hand and take the oath? Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? Thank you.
Normally, the district's exhibit is marked as A, and the petitioner is, 1, 2, 3.
Right.
So I think Austin Stewart is from the district, so it should be A.
Well, the petitioner is the district.
Oh, yeah. Petitioner is the district. Well, it's no longer, okay, yeah. So it's the other way around then. A, B.
There's nothing from the respondent, right?
The
The
declaration.
declaration of Bob Wilcox is from the respondent, but we don't have any objection to the numbering. This is a consent package, so we don't have an objection to the numbering that the vice chair indicated earlier.
Well, no, let me fix that. Thank you for pointing out. So, Hernandez was 2. We'll make the proposed findings, we'll make Stewart 3 and make the proposed findings stay as 4, and I'll call Wilcox A. Yeah. While we're waiting for the additional hearing board exhibits, is there any public comment on this matter? Subject to 3 minutes. Any public comment? Anybody in the audience who wish to provide a public comment? Now, I did have Mr. Armbruster with a comment card, but I take it that's replaced by you being a witness as called by your attorney, et cetera?
The comment that was submitted earlier was to request that we would go on first because I had a travel conflict.
And obviously we ignored you. Sorry about that. And then I had Andrew Brody. Oh, that was you. Okay, same thing. Okay, good. My apologies. I mean, I can't tell if someone on the video has their hand raised for public comment or testimony.
They might.
So, Day, do you have any idea if there's anyone on the video who has a hand raised for public comment on this matter?
No, sir. No, there's no
Madam
one
Clerk?
with their hands.
Okay,
raised.
good, good. So you have some exhibits to hand out for us, Madam Clerk, I think? The email communications, I guess?
Did you have another?
No other exhibits.
Thank you.
No.
Thank you.
Madam Clerk, in your absence, I took it on myself to botch up the numbering, but just so you know, we had the stipulation as 1, Hernandez as 2, Stewart's declaration as 3, Hernandez declaration. Stewart declaration is 3, proposed findings as 4, the Wilcox declaration as respondents A, and we'll call this batch that you provide as hearing board 1. Which is the email communications with, among others, Brady Lee, respond to Mr. Belkapon's questions. So, order for abatement. All right, we'll have the district make an opening.
Thank you. Good afternoon, members of the board. Before you today is a stipulated order for abatement petition involving the regenerative thermal oxidizer, or RTO, which is an air pollution control device located at Respondent 3M's Irvine facility. In its petition, the district alleged violations of Rule 1147 and Rule 203 for the permit condition requiring compliance with Rule 1147. Specifically, the district has alleged that respondent's RTO has not demonstrated compliance with the NOx and CO emissions set forth in Rule 1147 through a source test that was required in May. And while respondent has not conceded to these specific allegations, the parties have spent significant time in preparation for this hearing, and we are in agreement that the proposed conditions provide a prompt path to compliance while minimizing NOx and CO emissions until compliance is achieved. Specifically, the proposed conditions require respondent to immediately limit operation to no more than 1 pound per day of NOx averaged over a calendar month. These limits were calculated using the highly conservative default emission factors for this equipment. Even under this limit, the facility's records demonstrate that the RTO has been operating well below the limit for the past few months since they have been keeping records. However, as a facility has not kept records to demonstrate that the RTO is below 1 pound per day of NOx since November 2022, which is what the rule requires, they are not exempt from demonstrating compliance with the emission limits under Rule 1147 D7A. Instead, respondents may apply for a new permit condition to add a limit of less than 1 pound per day of NOx as set forth in the proposed conditions. Additionally, respondent has agreed to source test the RTO in order to determine actual NOx and CO emissions, and they can use these results for the permit if they do seek permit conditioning limiting 1 pound per day of NOx rather than the inflated default emission factors. Respondent has already moved proactively in submitting the source test protocol for the RTO. As of yesterday, the district has approved this protocol, so they are moving ahead of schedule. All of this information is laid out in the declarations submitted for district engineering and compliance staff, as well as the declaration from respondent's representative, which were submitted in the party's request that this matter be heard on consent. But district witnesses are available today should the board have any questions. As the board is well familiar, under Health and Safety Code, Section 42451B, the hearing board need only find good cause to grant a stipulated order for abatement. Finding that the respondent is in violation is not required. And the parties have worked in good faith to reach an agreement that will expeditiously ensure compliance while minimizing NOx and CO emissions. We ask that this hearing board find good cause to grant the stipulated order for abatement according to the proposed conditions submitted by parties. Thank you.
Thank you, Mr. Brady.
Good afternoon, Vice Chair, members of the board. I'll be brief. We come here today in full agreement with staff. There was a dispute about past compliance, but we've come to an agreement with staff under a Rule 1147, which has multiple pathways to compliance, of a pathway to compliance that works for the facility, and there are steps to get there. One of the questions is, why do this source test when we are very confident it's not going to meet the 20 ppm limit? The reason is ultimately that the pathway to compliance here that's anticipated is to seek to amend the permit with a 1 pound per day limit. As counsel for the district, Ms. Lee, mentioned, the data we have thus far indicates that this piece of equipment can operate comfortably under that 1 pound per day limit, even at a very conservative default level. We believe with the source test, we'll be able to show that the actual 1 pound threshold will actually even be higher. So this is a piece of equipment. This is again, 1 pound per day is a sort of de minimis limit under Rule 1147. This is a piece of equipment that operates comfortably under it. So we intend to amend the permit once we have the source test data to set a 1 pound per day limit, and that will be the daily go forward limit for this piece of equipment. We've set up electronic monitoring. And you see that in the declaration of Mr. Wilcox that since June 20th, I believe, we've been daily monitoring and will, in accordance with the terms of our stipulated OA, continue to report that and then continue to comply with the 1 pound permit limit on a go forward basis. We thank staff. I think it was a very favorable experience working with them. It was very collaborative, and we were able to, I think, to come to a viable pathway to compliance that works for everybody.
Thank you.
And if I may add, we do have our witnesses here. We do not plan on putting on any affirmative testimony, here to answer any questions that the board may have.
So, Ms. Lee, then you have no affirmative testimony to present? And we rely on the paper submitted in your opening statement?
Yes, that's correct. But we have the witnesses here available to respond to any of the board's questions.
So board members, do you have any questions that you need to ask of a district representative, you believe? Mr. Okan?
Yeah.
Who would you like?
Could I have the district engineer?
The district will call Mr. Austin Stewart.
the oath this morning, Mr. Stewart?
Yes, I did.
All right, please state your name, spell it, and your title, please.
My name's Austin Stewart, spelled AUSTIN STEWART, and I'm an air quality engineer level 2 in engineering and permitting.
Okay. Good afternoon, Mr. Stewart. I don't know, did you see the questions I had submitted? And I was going to go through that, use that, my questioning. But before I go, that limit that was set, I heard is a very conservative number, ppm. What was that based on? What was the ppm or the
Yeah,
BTU per?
it's based on our South Coast AQMD AER emission factor of 130 pounds of NOx per million standard cubic feet, which equates to about 102 ppm NOx.
102 ppm NOx, okay. And can I ask why you chose that number?
The equipment hasn't been source tested, so that's the value we used as default.
Now, in the previous, in the regular petition when they submitted, they said that they did a test, right?
Right.
And not approve, they didn't submit a protocol, but what's the term they used? They did preliminary testing, which indicated their ppms are 58 ppm. You saw that, right?
Yes, I saw that.
So what, as per the rule, I know there was, when it was issued initially in, but let me put that, rephrase that. When was the permit initially issued for this piece of equipment?
The permit to construct was issued on or around September 2007.
September 2007, okay. And what was that reference application number?
That would be application number 472484.
So 2007, and so the version of the rule that was in place at that time was, for 1147, was that even adopted?
It was adopted 2008.
8, right? So, and what was there any requirement for testing or any, at all on the burners?
Not at initial.
So there was, okay.
Construction.
So that was, the permit was issued without a condition to comply with 1427, correct?
1147.
1147,
Correct.
sorry. 1147, correct. So then the permit was, when was the permit then reissued, or when the permit to operate was issued?
Would be on or around 2010, I see. And then that rule 1147 reference was added.
Right. I mean, say on around, if there's a specific date on the permit, can you just cite that date? And which application number is that?
There was some modifications along the way during the PC, like a PC chain. So the final permit to operate prior at the prior facility ID before the change of operator would be April 2013.
April. What about the one in 2010, which was what was attached with the permit 499302? Was that?
Can you specify which permit?
499302 application. I think that was in your email. You listed those application numbers, so that's trying to get.
This is the email from him. I think it was here.
That's it. That says 535,931 for the application number.
499302 is,
Point three of the response message from Ms. Lee, paragraph three, the second paragraph that I mentioned. 499302.
yeah. And that was, it was issued for 1/2010, correct?
Right, under G07932.
Right, and the one you just cited was subsequent amendment to that permit?
Correct.
So that's final one before the change of operator,
Yes.
and then they issued another one after the change of operator,
Yeah.
which, okay. So the condition in the previous permits, that were permit to operate that were issued, had they should comply with 1147, correct?
Yes, it had the condition.
Condition, right, and the rule at that time didn't require for the afterburners until they are 15 years old.
15 years,
So
correct.
what was the age, was that determined, if the permit to construct was submitted in 2007, what do you think is the age? Did you get a confirmation from the facility what the exact age of the burner was?
We have in the application file notification February 2009
But
of installation or construction.
But you say 2007 though?
That was the initial permit to construct.
Right, so.
But it wasn't constructed until.
But they were going to purchase it. So approximately what do you think is the age then? 2009, you said?
Approximately 2009 would.
Did you confirm with the facility based on the nameplate or age? As for the rule, there's a definition of how you determine the age.
I don't have that information.
You don't have the information, okay. And my question is 15 years from that date, they have to comply with the limit, correct? In the
Correct,
table
from
one.
the prior amended rule.
Prior and amended rule. And then, and what was the limit they had to meet at the time?
To my understanding, the table one emissions
Table
of
one,
60
which is
ppm.
how many ppm?
60.
60,
ppm.
which is 60 ppm, correct?
Yes.
Yeah. Okay. No, okay. And the issue, and because I mean, I saw the proposed finding and decision document, was if the source does not in its condition under order condition 6 comply with rule 1147 20 ppm limit. Now, based on your understanding and the age of the burners, do you expect them to meet 20 ppm?
It's unlikely, but that's a compliance option.
Yes, but it's unlikely, right? I mean, if they have tested it before and showing 58, will those burners, based on the age, do you think, in your opinion, will meet 20 ppm?
Engineering's opinion, no, but they have not been source tested by a approved protocol.
Right. Now, when you talk about approved protocol, they don't need an approved protocol. They can do a test, but they take the risk in case they didn't follow the proper test method and so forth, right?
That's correct.
Okay. So the thing is, why even, we know, at least when I look at it, it's clear they won't meet the 20 ppm. The burners are old. There's no way they can meet initial testing or preliminary assessment showed 58. I mean, to do the preliminary assessment, they had to run a test, correct? Using the NOx or whatever method it was, right? Or would they have done it any other way?
I don't have that information of the testing.
So presumably they probably did, I'm assuming, okay? Now maybe I'll find out from the respondent. If they were at 58 ppm, why not and it appears that they are willing to take a condition, amend their permit to meet the 1 pound per day, right? Why not have them submit that right away?
We may use the results from the source test to limit less.
Yeah, at that, that 60 ppm was the limit in the rule. Use that as the basis to calculate the pounds per day, basically.
Mm-hmm.
So you give some operational flexibility as long as they. So let me back up. Let's say they do the test. It looks like they got the sources approved, and let's say tested for a reason 35 ppm. Okay, and so are you going to calculate the the fuel usage based on 35 ppm?
If the source test report says it's able to be used for emission calculations, yes.
So even though that's a snapshot in time, and the limit is 60, if you're following the table, so you would and then once you base it on 35, there's no further requirement to do testing like every 5 years because they're below a pound, correct?
I don't have that answer right now.
Yeah, so you're basing hypothetically if they meet 35 ppm, and you base your usage based on 35 ppm, which could vary. I mean that's a snapshot, and that's why I'm concerned. Why not use the upper limit, which is allowed, which is specified in the rule, 60 ppm? And we know, and I think we heard the testimony, they're way below, even with, I calculate 60 ppm based on the usage they have provided, about 0.3 pounds. So there's no issue with complying with the 1 pound per day. It looks like they've already got the fuel meter in. They got electronic data already going. So why not submit the application right now and modify the permit? Why do you need a test that may or may not to be representative of the full? They got 58, and of course I would say if it's 75 ppm, use that number. But if it's higher, but 60 ppm is the limit in the rule for those burners after 15 years, basically. So right, that if they had done the test, if they're supposed to, when they were supposed to do it after 15 years, the age is old. The limit they had to meet was what?
It would be 60 per
60,
table 1.
60
Yes.
table 1, right? Okay, so that's one. And then when did you know they were doing a change of operator?
I'm not too sure.
Okay. Were you aware they were doing a change of operator?
I was.
You were aware, right? And you also know they submitted an application to do the change of operator.
I wasn't informed of when the forms were submitted. I just was made aware because checks were sent in.
Okay, so you didn't tell staff in permit services, hey, that one may have to amend, the permit because they're not in compliance, hold off on that or anything like that? You didn't?
No, I wouldn't do that.
Right. And I think the response was, when I asked that, it's strictly administrative, no evaluations conducted, permit condition untouched, which is true for command and control, but that's not true for reclaim or Title V type facilities, correct? Because there is an opportunity for, see, when the permit was issued, and it was very recent in, when was the last time the change of operator was in March, right? No, let's see, when I have.
May.
May, right, yeah. The permit was not even updated to reflect, were not provided with conditions saying, hey, look, the rule has changed, there's a source test requirement and so forth. So the facility was not informed at all, correct? Of the requirements of the rule. It just says you comply with the rule, basically, which was what was in the old permit.
Which was in the
old permit, and it was just carried over.
Correct.
Right.
Strictly administrative.
Strictly administrative, and I actually had a hand in because had that happening, but because command and control for that permits, so that was the main concern I had, was have them submit the application for the modification to the permit to take a condition to limit them to 1 part per day, use the 60 ppm limit, and issue the put the requirement. And my question is, why not do that?
Because we would need the source test results to verify the NOx ppm.
Not this. Okay. Have you talked to your? They've been a lot of, to my knowledge. Okay, let me put it that way. Permits that were issued for less than 1 pound per day. Companies have taken conditions to limit their emissions to 1 pound per day. Right? You don't require sources to do that. Right? You just go with the rule limit. Correct? I mean, whatever is, you have two things going, and I'm not testifying here. One, they are submitting with the application, manufacturer certification, what kind of PPM they limit. Two, there's a rule limit, 60 PPM. So are you aware that in the past, when permits were issued limiting them 1 pound per day, the rule limit was taken and then calculated based on that, which 60 or whatever PPM, and then they were issued, didn't require a source test, because it sort of defeats the purpose of doing, why do a source test when you can accept that condition, is my question,
I guess we would still use the South Coast AQMD emission factor, the 130 pounds of NOx per million standard cubic feet at this moment, without the source test results.
And not the rule limit?
And not the rule limit.
Why is that? And the reason I'm asking is not only because of this particular facility, because I think there are many other facilities in the same situation that may be coming before this board. And I want to get an understanding why is that thing, why does that construct that way, Because I heard that before in another case also. I didn't question it because it was an excess emission issue. But so why would you use when the rule limit specifically says 60 ppm?
Because we would require a source test in Rule 1147 to demonstrate compliance with the table, which has not been done.
All right. And all right. And that's really where I was coming from. I have no, if the company wants source tests, but I do have an issue if the source test comes out at, let's say, 40 ppm and the emission, the allowance, and I mean, it's my issue. If you don't have a problem and the permitting doesn't have a problem, that's fine. I just have a concern, let's put it that way. If the test comes out at 40 ppm and you give a higher usage based on 40 ppm, and it's a snapshot, and they could go up to 58 or 60 or higher, with the source test, and there's no subsequent sources required. You don't see that as an issue?
I mean, once we get the source test results, we can make that determination on what the limit would be on the permit to limit less than 1 pound per day.
All right, fair enough. All right, I think that was the issue I wanted to raise, basically just to make aware, and maybe that's, I didn't mean to bring everybody here for this, but I do, even though I think the comment was made, there's a very low emission, but we have cases that come before us with extremely low emissions or no emission, and what we do. And I'll reserve my other comment during the closing argument. But that was the issue I had, Okay, I've no further questions.
First, any board members with questions for this witness? Did you want to examine your witness at all on this, Ms. Lee?
No, I have no questions for this witness. Thank you.
Ready?
We have no questions for the witness. Thank you.
Thank you, sir.
Just the compliance inspector, just a question.
The district calls Inspector Daniel Hernandez. Mr. Hernandez, did you take the oath today?
Yes.
And can you state and spell your name for the record?
Daniel Hernandez, DANIEL HERNAN, Air Quality Inspector 2.
The district has no questions for this witness.
I don't know.
Would you at this point, Mr. Brady?
None at this point, but we'd reserve the ability to cross based on any testimony from board member questions.
Mr. Hernandez, what is the current permit regarding Rule 1147? What is the condition on the current permit that was issued regarding Rule 1147? What does it say?
Condition 4 on the current permit requires just compliance with Rule 1147.
Okay. Have you inspected this facility?
Yes.
When was the last time you were there?
May 1st, 2024.
And prior to that?
I have not visited this facility prior to that date.
And do you know if there were prior inspections by other inspectors to this facility?
There has been, but it's been several years.
Several years. So how did they deal with that condition? And how, if you know, if they did anything in the inspect?
Yeah, sure. So normally we would handle that condition with, if there's no prior source test to base off of, and there's no requirement in this case for record keeping, we would look for records from the facility if they have it to find if they're under that 1 pound per day. Because they already had that, in this case, they had the fuel meter installed. So that's what I was looking for in this case. They didn't have those records in this case. So I wasn't able to use that to determine compliance.
Right. So if you were to inspect it tomorrow, what would your inspection say?
Clarify it.
Well, let's say hypothetically, you're going to do an inspection tomorrow, and based on the current conditions saying you should comply with 1147. My question is, would you say, because they're keeping, because we know they have the meter and they have electronic data keeping, and if you're doing the inspection, would you say they are in compliance with the permit condition?
If the data that they showed that they were less than 1 pound per day since the last inspection, then I would say that they were in compliance with 1147 since the last inspection.
Okay, that's all I had. Thank you.
Any other board members with questions? Any further questions from Ms. Lee or Mr. Brady, this witness?
No further questions from the respondent.
I thank you, sir. You're dismissed. Both parties rest on the witnesses they've called or not called.
Yes, no further witnesses.
Okay, on to, before you go to closing, let me just say that I appreciate Mr. Balkapan's question, because I thought the paperwork was the original paperwork was unclear about whether 1147 was in violation or not. It was unclear why you couldn't tell us for sure how old the burner was that affected the rules. And it wasn't clear that the 1 pound per day option was being given to them. You clarified that in the dialogue with Mr. Balkapan, but the initial papers were kind of ambiguous, just so you know. I found the same problem. With that, you may start your closing, Ms. Lee.
The district just would request again that the board find good cause. The parties have worked hard to reach stipulation on the proposed conditions and believe that it will ensure an expedited path to compliance. Thank you.
On behalf of the respondent, if one of the board members wants to make a motion, the 60 ppm limit be used to determine the 1 pound per day, and we can forego the source test, the respondent would agree to go down that pathway and could submit an application within a week or two. However, we do believe that the conditions as set forth are appropriate. We'll get to a 1 pound limit that is indicative of this piece of equipment. We do not think the 102 ppm limit is appropriate, because that would effectively change it from 1 pound to actually something much lower than 1 pound for this actual piece of equipment. So the source test would be necessary for that. I think either way, we're comfortable with either motion the board would make and would support it.
I'm sorry. There was one question I had for the respondent, Mr. Wilcox. If you want to bring him, introduce him, and I'll just have a quick question for him.
You've been sworn in, correct, Mr. Wilkins? So you're under oath. Please continue.
Yes, I have taken the oath.
Mr. Wilcox, if you can just state your name for the record and your title.
Bob Wilcox. I'm the plant engineering and tool room supervisor for the Irvine site.
Okay. Just one question, and can you explain how the burner operates and how long does it take to how the burner operates, and basically.
Yeah, so the machine is regenerative, being that it heats up the beds, and it uses natural gas to do that. as we feed in VOCs, that fires and continues to heat the burner. So the more VOCs that we put in, the lower the burner runs. And the machine runs 24/7 essentially.
So once you initiate the combustion, you turn off the burner? I mean,
it doesn't, it goes down to an idle state, a minimum opening.
okay. So it's still,
It has the capability to shut the burner off. However, the corporate guidelines is they don't want the burner restarting with no personnel present.
okay. So it does does it take 5 minutes or less to bring the unit to minimum operating temperature?
From a cold start?
Yeah, cold start.
Oh, no, it takes hours.
Hours, okay.
Yeah.
Okay, that's all. I was just saying if there's an exemption if it's does take less than 5 minutes. So you said hours.
Yeah,
to
there's
get-
there's a minimum, it's actually throttled down to heat up at, whatever it is, 10 or 20 degrees per
Higher,
minute. So it's controlled so that it's not overheating.
Okay. And when you, sorry, I had one thought of one more. When you did that assessment, were you aware of the assessment that was done to measure the emissions?
Yes, I was involved with that.
You were involved, and as far as you know, you had a testing company come out and do that?
Correct.
And can you tell me what the name of the company is?
I believe it was TRC.
TRC, and as far as you know, they follow the protocol to do the testing,
Yes.
and the test showed 58 ppm.
I believe that's what it was. I don't recall exactly.
And do you believe, do you have and I apologize, I'm getting questions coming up as I'm talking to you, the age of the burners, the age of the burner?
When you say age, are you talking about from the date it was constructed or from the date it went
Let me
into
ask
use?
for the definition and the rule, and I'll stick to that.
Okay.
And so I don't know if you. Somewhere there, a burner age shall be based on the original date of installation or by an invoice for the burner manufacturer or information submitted to the district or rating plate. Normally they have a rating plate and says manufactured, effects to the, on the unit.
The actual burner itself does not have any date on it when it was manufactured. It has a model number, serial number, manufacturer name. We took possession of the equipment, I believe, at the end of 2007.
2007. Okay, so 15 years would put it around 2022, basically, when you were supposed to do the test.
Correct.
Okay, all right. Now, that's all I have. No more questions. Thank you.
Ms. Lee?
No questions for this witness. Thank you.
All right. Thank you, Mr. Wilcox. You're excused. So I believe you finished your closing, Mr. Brady?
Yes, thank you.
All right. Any board members want to make a motion for finding good cause of the stipulated order for abatement? Pointing to him.
Who made them come in and let me just for order abatement, I take it more seriously than and the first time my sort of it's not a written principle. When a facility comes in for order abatement, I like them to appear. Subsequently, you come for a modification, so forth. We heard you, we know your history, we know what the situation is. Really don't, so, but an order abatement is a serious level, where the facility can be shut down if they don't comply with the condition. So that, so regardless whether you have no, minimal emission, whatever, so that I have approved order abatement, consent for order abatement, one previously because they were not operating, basically, there was no emission. But so that's part of the reason, why I didn't want to, agree to consent, because I think for me anyway, order abatement, we need to hear from the parties and then subsequently fine, and then plus I had some questions I wanted to raise, which I didn't want to go back and forth with the, back and forth with the questions. So that's the reason why. So,
I do want to just say one thing, because I, like Mr. Pearman, did appreciate your questions. Once I saw them in print and I thought, oh yeah, that's a good question. We do need to hear that. So I do appreciate you.
Appreciate that, yeah. And so if you have already, the only reservation I have, and that's only me, and if the agency, permitting agency wants to do, based on the sources and, my issue is, they should look at that, revisit that, and not use based just solely on the source test, because if it's a low number and then you get a high usage. But in your case, you know, the usage is so low based on the 3 months record you submitted, so it's not an issue. So I will make the six, I'll find a good cause, even though, you know, to grant this, this variance subject. So I'll make the formal motion if you like, you know, let me.
Order for abatement.
Oh, order abatement, yeah, good cause for this order abatement. Let me get my cheat sheet so I do it correctly. So now I don't have to make 6 findings, so, you know. I'll do that because I dragged you all in here, so. And having you miss your flight was not intentional, but, so in the matter of, order abatement, actually in the order abatement, so in the matter of, 3M Healthcare US Opco LLC, case number 6256-2. Motion that we find good cause to grant the requested stipulated order abatement as per the conditions outlined in the finding and decision document.
I'll second that.
Any further deliberation? If not, Ms. Verdugo Peralta.
Aye.
Aye. Alanga McCutcheon, how do you vote?
Aye.
Mr. Belkacon?
Aye.
And I vote aye as well, so it's unanimous. Thank you very much. That concludes that matter, and we are. Thank you. Thank you. Well,